Happy Tuesday. It's time for coffee and cursey words. I've got coffee. I have cursey words. It's been a long weekend for me, and I'll share a little bit about that in a moment. Today, we are doing a very short, quick bits. By very short, I mean very short. Then we are doing two stories. I'm just going to give you my thoughts and kind of what I'm looking for as the Rittenhouse trial is now in jury deliberations. And then there's a boatload of new Duggar motions because those motions in Limine that very much matter for how the trial progresses are still going on. So we're going to go through the responses to the motions in Limine together and just have a chat. That is what we're doing. Welcome in. Let me know where you're coming in from, what you're drinking, because here we are drinking bulletproof coffee this morning and having a chit chat with all you amazing law nerds. And I've got new audio. So if I play with that a little bit, sorry, not sorry. I don't even know if y'all can hear it when I do it. But I have a new mic setup and that might be fun. I don't know. Can we just I don't know. If you, maybe not. We'll see. We'll just see what happens. Because I should change the audio output and then I can hear what you can hear. That's Emily. We're professionals here. Look, new setup. New setup. Maybe you can hear the kids going wild. Maybe not. I don't know. If the crowd goes wild, we'll see what happens. All right. I'm gonna just roll this and we're gonna get going, and that's what we're gonna do. So thank you for being here. Thank you for being a law nerd. We've got a lot to talk about. Let's just do the things.
Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery.
You guys, I'm going to sneeze. It's going to have it's percolating. So just know that is going to happen. I'm trying to not make it happen, but it's going to happen. It's so good to see all of you coming in. I am in a mood. Look, I had a weekend. I lost a friend this weekend. I might share more about it on social at another time. I'm definitely not doing that just yet. But if you're like, Emily, are you okay? I'll be okay. But it's a little raw. So I'm just like, so when those of you who are like, Emily, your energy's a little heavy today. Yep, 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 it is. Yep, sure is. So that's just the way that look, life is life. And we go on and bring the facts, not the fuckery. So please, for all of you, thank you, everybody. It just is. Grief is one of the things that when I became a DA, I was not aware of how much a part of that job choice it would be and how many losses there would be. So look, it's not like in 2020 and 2021, loss is unfamiliar to us, right? It's just one of those things that is all too ever present, right? So if you're like, Emily, what's up? That's what's up. I will probably share about it more later because he's an incredible human, but I'm just I don't know. It's so weird on when you're on social because I love all of y'all and I want to share with all of y'all, but I'm also not always ready to share. So, and also I realize that just sharing um it's not just sharing with a small group anymore. And so there are some things that need just a little time before I talk about them more. So thank you for all the purple hearts. I just wanted to share because if I'm sure somebody would be like, well, see, she wants this and she wants that because of how she presents on video, because that is when your videos get views, one of the things that happens. And so I just wanted to share where I was and why I was. And this community has dealt with so much loss, and I see it in the chat regularly. And it's something that we all deal with as a human, and it is one of the hardest things to deal with. And it just feels like it's been so much. And maybe it's just feels more present, but it just feels like it's been so much. So Not okay, but will be okay, but hate processing grief. It's just not, it's not my favorite by any means. I'm much better with shoving things down and not addressing them, which is not something I want to do. So now that we've talked about all of the feelings, I just wanted to let you know why I was a little off. But I also wanted to come on because I really do like talking to you guys about these stories and really do like having a chat with the law nerds. Even though there was a part of me that was like, are we ready to talk about things on Tuesday? I am. I want to talk about the Britney Spears minute order from the judge, the like official minute order, like the official court ruling that she's free. I really do want to go through these Duggar motions and see what the lawyers are doing. I've actually really been curious about the lawyering in this case. I really enjoy the lawyering in the Duggar case. And I think talking about the Rittenhouse trial as the jury's out on my own platform instead of just doing commentary on other platforms makes sense. Oh, I forgot to grab my notebook so I can note timestamps. Because replay crew, I love you. Ah, my cats keep stealing my pens. It was like set up on my desk before my stream, and Fred stole it because he's Fred. So replay crew, we love you, and we will have timestamps down below after I'm done with the chitty chatty chat of all the things. But I thought it would be helpful to talk about the Rittenhouse trial as well, just from my perspective as a DA, especially with some of the stuff the DA has been doing in this case that I don't agree with. Just look, we all have different opinions. Um, I don't agree. I don't like it. Yeah, I'll talk about that as we get to that topic. But I've also been on other channels doing commentary about it. And I know some of you are like, we love following you around the internet. And some of you are like, I cannot. And that's totally okay. I really don't limit who I interact with on the platform when it comes to the other lawyers on the platform based on their channels, not on my channels. It's more of a, can we have a conversation and can we disagree from different viewpoints and have that conversation? And I really do often find myself engaged in conversation with people who I don't agree with on some things, on all things, but also as a lawyer, that's not unfamiliar to me. And I think that that's one of the most important parts of discourse because I can only see things from my perspective and others see things from different perspectives. And I always try to learn from different perspectives. So that for those of you who are like, I don't want to go and see you on, Nick Ricada's channel, that's okay. Don't. Trust me, his commentary is not for everyone. He and I don't see eye to eye on a lot, but I like having the conversations, even when I disagree with where other people are coming from, and even when they disagree with me, because it's how A, we have good discussions, and it's B, a part, it's not unfamiliar to being a lawyer, but if we particularly for me, if I silo myself in my own like thought bubble of only people that agree with me, it doesn't make me a very good critical thinker and it doesn't make me better at parsing information and it doesn't make me better at um evaluating how people are thinking about things. I want to have discussions with people who don't agree with me and people I don't agree with because that's the only way I'm like, "Oh, I understand your perspective and I see why you see it that way." And maybe some will understand why I see it my way. And I think that that um is is important. And so I even see in the chat, Mr. Unicorn, it's you don't have to support creators that I have a conversation with. You absolutely don't have to, which is why I choose the difference between whether I go on someone's channel or whether they come onto my channel. Because as law nerds, it's also your choice. And it's also okay to say, that's not for me. I don't want to have that conversation. It's completely fine. I just wanted to share with you why I have those conversations and why I think those conversations are important to me and why differences of opinion are important to me and why understanding is important to me. Also, yeah, so that's that's what that is. That's why it matters to me to have conversations and not always easy conversations because there's definitely things on stream that I'm like, what we're not going to do is keep making fun of the prosecutors. Wait. But also, I'm not going to tell people how to act. I'm going to tell them that I disagree with it. So that's where I come from. And that's why I bring that perspective. And Nick, for I'm sure a lot of you also don't agree with him and don't like the way he interacts. It's fine. It's him, it's his channel. But he invited a panel, a very diverse panel of lawyers onto his stream to say, let's have the conversation. And I'm here for the conversation. So um that's what it is. So I like having the conversation. And I also turn off the chat because I can't with the chat. And that's okay. So let us go. But also I follow people on Twitter that I don't particularly like and don't agree with because I don't I don't find myself understanding the why of things happening when I don't see it from two perspectives, even when I don't like the perspective, if that makes sense. And I find that that's something that's ingrained in me from the work that I've done is I want to see the different sides of the thing and have the different conversations. So so that's where I'm at. So, and no, oh no, I'm talking about Nick Rekieta's, not the viewer voice. The viewer's voice has not been live streaming legal commentary that I know of, but if that happens, I will absolutely check it out. So I just wanted to discuss um why I do the things I do and why I value having those conversations and why I appreciate other legal commentators who all run more conservative for sure than I do. Why I like having those conversations with different viewpoints. It's interesting because I am so not I'm so not anywhere other than squarely in the middle on a lot of stuff that it's interesting to have those conversations and be like, I'm not quite sure if that's how I see that, or I'm not quite sure if I agree with that. So that's what it is. We will be getting into that later. I just wanted, well, really to just have a chit chat. And look, if I refuse to have the conversation, isn't that me getting into fuckery? Like if I refuse to call out and say, "Hey, that's not cool." Isn't that me also just being like la 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 and not having the conversation? So, let us move on. We are law nerds. We are here. We are going to get into some difficult topics today. I appreciate you having the conversations without um without the name calling with because especially the Rittenhouse trial has become very polarized and I want to talk about what happened in the closing arguments and what the jury's going to be deciding with because that's just what's happening in court. Those are just the facts. I know it's polarizing and I will never tell anyone not to have their feelings. What I will say is what we're not going to do is lambaste people in the chat. So I appreciate that. We keep this chat as a place to have discourse and a place to have conversation, not a place to name call and scream and silo. And I know you all know that because y'all are law nerds. So let us get into our quick bits. I love quick bits, but today's quick bits is just a quick bit. Quick bits. Look, we had to have some good legal news this year, and the good legal news this year is Britney is free. That's it. Britney, oh, I didn't timestamp myself. Darn it. We'll figure it out. Britney's free. I wanted to show you the actual minute order and if you guys want me to, I will share a Dropbox link to it so you can download it if you want your own memorial minute order that says Britney's free. I will look. Let's all just take the good with the good and enjoy it because Britney has been freed from her conservatorship. There are some winding up things that are going to happen. The winding up is really just financial and I love it. So let us get into that real quick. Oh, of course, we're professionals here, and the screen sharing is not screen sharing. Um, it just is what it is. Karen R, I appreciate that. No reason to explain yourself. You're doing what you like and not just what your audience wants. Yes, I like sharing because I don't want people to feel hurt or to feel betrayed or to feel like, girl, what are you doing? So I like to have the conversation about why I want to have the conversation. When Belly, thank you for the super chat. When we get to Rittenhouse, I will absolutely answer this. I have very strong feelings. And they are feelings. They are absolutely feelings. So let us talk about Britney's minute order. Yay! Look, interesting things. All right, this is from November 12th, 1:30 p.m. Nature of the proceedings: petition to terminate conservatorship filed on September 7th by James P. Spears. This was filed by James Spears, by Yeeted Spears, and his lawyers, Vivian Thuren. Look who's not on the list of people who are present. Viv didn't come to court. Look, Viv didn't have to come to court. Viv's no longer James Spears's attorney, but this was a motion filed by Vivian Thuren. If she wanted to show up, I don't think anyone would have been like, why are you here? It's their motion. They filed it. But Viv's not on this list. Viv's not on this list at all. Jody Montgomery was there, the conservator of the person. James Spears, the yeeted conservator of the estate. Lynn Spears, Brittany's mother. John Zabel, who is the new temporary conservator of the estate. Lorianne Wright, and then the rest of the attorneys. But in this list of attorneys, and who was in person, um, Justin Brian Gold, who I believe is working with Zabel, Matthew Rosengart, Lisa McCurdy, and Alex Weingarten, Lorianne Wright were there in person. The rest were via Court Connect. But even via Court Connect, Brittany was not present at this hearing, which is why we saw Rosengart in his statements afterwards saying he needed to go talk to his client. And not only that, but Viv and no one from Viv's firm was present. Isn't that interesting? Isn't that interesting? Isn't that interesting? Hmm. I think so. I think so. This matter is called for hearing. The court takes testimony. The court finds that sufficient evidence has been provided to the court to grant the matter on calendar this date based upon the reading of the moving papers and consideration of all evidence presented. Petition to terminate conservatorship by James P. Spears is granted. Yay. I think one of these is clapping. Wait. Can you guys hear that when I do the clapping? I hope so. I'm not sure how it works yet. We're still working it out. Hopefully you can hear the crowd going wild. But if you can't, I intended for you to be able to. I don't know. I'm gonna have to do a members only stream and mess with this and see if we can make sure that the audio is playing through here as well. So either way, oh, you guys can hear it. Yay! All right. I'm so excited. And I have sound effects. So watch out, world. Watch out. We have sound effects. Ooh, I can do a yeet sound effect. I'm going to have to do a yeet sound effect. I'm going to have to. We'll do one. All right. The court finds and determines that a conservatorship of the person and estate of Britney Jean Spears is no longer required and is terminated effective this date, with the caveat that John Zabel is, as a follow-up and conclusion of his services as temporary conservator of the estate, is to complete the following. John Zabel is to file a substituted judgment, which has been filed with this court this date and shall be assigned a hearing date of December 8th, 2021 at 1:30, and is ordered to transfer assets into the trust, which means all of the assets are being transferred into a trust for Britney that is going to be overseen by business managers and by not just by business managers, but also by financial managers. And Jazz said, oh, Emily has a new toy. Facts. Facts, facts, facts. So this is the court on its own motion reschedules all matters. So December 8th was supposed to be the court date for all of the financial stuff, including the 12th accounting. That's not going to happen until January 19th. What I think I'm going to do is an episode of the Emily Show just on the 12th accounting and break down the ins and outs, because that's been going on for like 2 years. And so I think we need a breakdown. It's time for a breakdown. Never gonna get it. Anyway, That's what happens in my brain. But it's time for a breakdown, I think, of the 12th accounting so that we're all caught up and that we can be ready for January 19th. Because there, even though Brittany is no longer under the power of this conservatorship, Brittany's Brittany's case is going to go on until my heart will go on and on. My brain is going to be like that all day today. Brittany's conservatorship will go on until the financial is done. So until the financial is done, we're going to still be here talking about the 12th accounting. The 12th accounting, again, is the one that deals with over $1 million in legal fees to James Spears. We're also going to have all of that, um, all of that fuckery with Lynn Spears's motion for attorney's fees. Like, I'm not done covering what's going on in the Britney Spears conservatorship. Britney gets to go live her life. Wonderful. Thrilled, happy, shocked that it's happening, didn't know if it was going to, but also, the financial stuff I'm very much interested in, and the ending with Britney being free from the control of others is not the end of this case. The financial part is the end of this case, and I'm so invested in following the money here that I can't like, we're not going to stop. We're just gonna be covering the money until I know, until we know what's happening, until it's, like, done. So, we will be covering that as it goes on. There was a hearing today. I'm pulling it up because if there's a minute order from this hearing, then I will quick bits this real quick before we move on. But let me see, where is it? Eh, my I've s w I the amount of federal cases that are still on my list that I'm covering is quite a lot, but I wanna see if there was a ruling in the Carol Baskin Netflix case because that came to hearing. So, let's see. Let's pull this minute order up. Hmm, Carol Baskin filed a response. We're not gonna get to that. What day is the 15th? That was yesterday. Um Gah! Okay, let's talk about Carol Baskin real quick because there is an order-ish. There's an order-ish. Um, I'm fascinated by the Baskin case. I'm just gonna tell you what, I'm fascinated. I'm fascinated. So we're gonna quick bits Carol Baskin real quick and then get on to Rittenhouse. So, Carol Baskin is suing Netflix to try to stop the release of Tiger King 2 on Wednesday. Yes, that's tomorrow. The federal court already denied a temporary restraining order. The standards are different for the temporary restraining order than a preliminary injunction. At a preliminary injunction, the defendant who's being sued, in this case Netflix, has the right to be heard. And that happened yesterday. Yesterday was a busy day with the closing arguments of the Rittenhouse case, and I was also just having a total day. So I did not look until this morning. But plaintiff's emergency motion for preliminary hearing, defendant's response, and plaintiff's reply were covered. Court convened, oral arguments by the parties was taken. The matter is taken under advisement. So the court is taking this under consideration. I don't know if the court will come down with a ruling later today or tomorrow, but this premieres tomorrow. Carol Baskin is trying to stop Tiger King 2 from premiering. Here's what I think is going to happen. I think even if the court I think the court is likely to deny this and say the remedy here is financial. If Carol Baskin didn't sign a release, then the remedy is that you have to pay her part of the proceeds you make from Tiger King 2. But you don't have to stop the release of it because until you release it, you haven't done the harm. Does that make sense? Like you haven't used the video until you've used the video and released it. So I think the court might lean that way. I'll be interested to see if the court is like, if the court's like, no, what we're gonna do is cancel Tiger King 2. I imagine that Netflix will then sue Carol Baskin for damages, and it will be very, very interesting. So let us move on. Yeah, I'm fascinated. Okay, the total time of the hearing was an hour and 40 minutes. So there was a bit of oral argument, and we're just going to be I'm interested to see because what matters in this case for me, the tea is kind of fascinating when Netflix's corporate counsel is like, she made so much money on Cameo. Like, I'm dead. But the things that matter in this are likeness releases if you get a likeness release, it doesn't allow you to reuse that footage. Can a network like Netflix just go around and be like, yeah, fuck off, whatever, we're going to use it, fight us in court? It puts people, not Carol Baskin probably has the money from the first one to fight this out, but it puts people who participate on reality shows, who are on, you know, on on network, competition shows like Drag Race or like America's Next Top Model and The Amazing Race. How and when are the limitations on using those appearances without compensating someone, without having the proper releases, and where is the boundaries of that? And when does the harm occur? Does the harm occur before it's released? Do you have to let the shit get all the way out of the horse before the harm happens? So there's some really interesting legal stuff that happens in this that I'm very interested to see how it plays out, because I think it has bigger implications than just Carol Baskin versus Netflix, because we've definitely seen individuals, and this happens on YouTube too, like if you sign one release to be on a show, or don't sign a release and then it gets reclipped and reused. What does that mean? So I'm really interested to see what happens here. All right. Are you guys ready to get into the Rittenhouse trial? We are talking about the facts that came out in court, the evidence, what the jury is going to be considering, and what comes next, what some of these options are. I know this case has become deeply polarizing, but we're talking about the evidence that happened in court. I don't think the evidence that happened in court is polarizing, and maybe that's me by being naive. I think the way the lawyers behaved is polarizing, and we'll talk about that too. So thank you for being respectful. No matter what you think of what happened with the shooting in Kenosha, there is still a 18-year-old on trial for murder, and 2 dead and 1 injured with, injuries that are going to change the course of their life. And we're going to just be mindful of that. We're going to just, ugh. We're going to go over really the closing arguments and my thoughts on them. Let me just swoop. Let's just swoop it and we're just going to get into it. Here's the thing with the Rittenhouse trial. I'm going to cover the closing arguments and what I thought. For those of you that are new here, you're welcome to pop a 1 in the chat. Hello. I am so glad that you are here. I am a former LA County Deputy District Attorney. I was a line prosecutor. Did I did trials. Not like this one. Not a highly publicized media trial, but I did trials that covered a very wide range of cases, including homicide. And my perspective on this comes from somebody who spent 10 years in court doing the things, and picking juries and making closing arguments. Always my favorite part, by the way. So that's kind of the perspective I bring to it. Every jurisdiction is different. I practiced in LA. LA is a very different place than Wisconsin. I did things differently. The things that I like and dislike in a trial are based on my own experience and my own temperament. Um, there were a lot of personal attacks in this trial. The defense can get away with that, I think, to a jury more than the prosecution can. The prosecution came across angry, like angry. I think personally that's never a good look, for prosecutors to come across hostile. I think it feels heavy-handed to a jury, but we can't see the jury, which is correct. Which is correct. The jury, you can see them if you're in the trial, but you cannot see them on TV. I think that's absolutely appropriate. The the attorneys have to read that jury, and they have to connect with the jury. And um I don't love watching, the defense saying, I need you people to understand this, because it feels like I don't love saying you people. However, him saying you people to the jury might be taken by the jury the same way as me saying you guys to a jury. Hey, you guys, this is what we're going to have to do, blah, 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 blah. Instead of saying ladies and gentlemen of the jury, the defense was saying you people. You people feels aggressive to me. It might be a regional difference. I don't know. I don't know. I felt like the defense's closing had more of kind of a down home vibe. He definitely, I think, leaned into more of a Wisconsin pronunciation of certain things, which on a national stage with this thing being screamed, with this being streamed, I think some might not understand, but I think it was probably the right call for that jury. This is a local jury in Kenosha, Wisconsin, that is going to understand the defense, the way he is pronouncing things, the way he's kind of bumbling. I don't know if all of that was intentional or if some of that is just this defense attorney. He wasn't super smooth. Um, he wasn't super he wasn't super polished, but that might also be just him. That might also be a choice. The prosecution came across much more polished, but the prosecution also picked up an AR-15 in court, put put his finger on the trigger and held that gun pointing at the jury. I think um it's just I don't understand why. I think you can get the point across to the jury, but the prosecution's very much leaning into provocation in this case. We're going to go through the charges in a minute. Um, and when we get through the charges, I think the reason that the DA did that, and I disagree, I very rarely brought weapons into court if there wasn't a question about the weapons. Um, I normally just brought in pictures with measurements. Um, because I thought that that was needed. There were a few times in cases where I dealt with knives where the knives were so much larger than they appeared in the picture, and it was relevant to the victim's retelling of the story that I would have the police bring in the physical thing, show it to the jury, and then admit a picture into evidence, not admit the physical thing into evidence. Because what you're not doing is sending a weapon back into a jury room. Um, so I was always mindful of that. But I really let me see. I can pull up for those of you that are like, "Wait, what the fuck is happening?" Let me pull up a photo of that so you can see what I'm talking about. Should have done it, didn't think about it, but Octonation is making a pun about how in shape he is, and that's true, Octonation, but I'm gonna say the only acceptable arms, we're gonna go with the octopus and not you, Warren, buff though you are. And yes, the 8 octo arms, absolutely accessible. DA Binger pointing an AR-15 at the jury is just Mhm. It's gonna be memed all over the internet, but it just doesn't sit well with me, and yeah, I'm just not thrilled by it. So let's see. Oh, the Daily Mail um is the first place that has the picture. So I'm pulling it up from the Daily Mail. So let me make sure that this doesn't slow down my whole computer, which it is. Good. All right. The Daily Mail is just such a heavy site that it's just making it hard to pull up. All right. Let's see. Know Your Meme, are we really gonna pull up Know Your Meme? Well, Know Your Meme's been used in court documents, so we'll just yep, we're going with that because it's not nearly as slow. Let's see. I mean, if Know Your Meme's good enough to end up in court filings and defamation cases, then Know Your Meme is good enough for us. Um, the jury is sitting right here where my mouse is wiggling. And so he has his finger on the trigger, not even along the side of the weapon, and is trying to scare the jury, really. So this is what DA Binger chose to do. He made this choice. This was not just a we're going to do this on the spur of the moment. This was a thought out choice while he's arguing provocation. And the reason he's arguing, yeah, you guys are like he put his finger. Yeah, his fingers on the trigger. On the trigger. Now this gun will have been handed to him by law enforcement. This gun has been in evidence. This gun has been in a police lockup, but still, a on the heels of the Rust shooting, it feels completely tone deaf, and B, I think this could very much backfire on him with the way that he did this to the jury because he came off so angry at the jury. It's not like um they're going to I don't think they're going to take it well. And I don't think this is going to receive and hit the way he thinks it does. He Pure speculation on the part of a trial lawyer that gives commentary on the internet. I think the intention here was to show the jury that this weapon is scary, that this weapon itself is provocation, and that provocation is what caused the others in the I don't know. I can't say audience. I'm struggling for a word. The others that were at the protests turned riots in the evening to be afraid of Kyle Rittenhouse. He's trying to argue that having the AR-15 was provoking enough that it essentially is picking a fight. Now, with y'all are asking for code red. Is this Binger fuckery enough for code red? I feel like the motion is granted. I'm going to play our code red intro. It is a little flashy for those of you that are flash sensitive. When the music stops, it is over. So we're going to do our code red and we'll go to DEFCON red. 1, 2, 3. And yes, I always do give a little bit of a warning. And here we are at DEFCON red for Binger putting his finger on the trigger of a gun and pointing it at a jury in closing arguments. I mean, between this and the constitutional violations, I feel like there's enough fuckery in this case that we just like are. Amy Yost said, I'm a cops kid and I've worked trials 20 plus years. I've never seen anyone point a gun at a jury. Same. But you never put your finger on the trigger unless you intend to shoot. Agreed. He was trying to scare the jury. And I don't, I think he could have made this point in another way. He could have made this point by holding the gun without aiming it at them, with holding it up, without a finger on the trigger. There are ways. This was a choice. I don't like this choice. I think this was a bad choice. I think this is something that could play very badly with the jury based on all the other things that the prosecution has done. So this is truly just what the fuck. That's what this is. This is a what the fuck moment in court. And you're just like, and I think jurors, and I see a lot of you in the chat saying I'd be angry. Yeah, and I think a lot of juries would be angry because it's tone deaf, but B, if you have to go to this length of trying to scare the jury to try to prove your point of provocation, then maybe it's not provocation. So I think it was a poor choice. It has been memed all over the internet. So I don't like it. I think he was trying to have a big moment in court. I think that big moment was tone deaf and turned out to be a what the fuck moment. There's been plenty of what the fuck moments in this trial. Other moments, Binger did in a closing argument at the end of a criminal trial, the prosecution gives a closing, open, close, initial close, closing argument, and then the defense gives their closing argument, and then the prosecution gives a rebuttal. And the rebuttal directly addresses what the defense has said or is intended to, because the job of the defense is to poke holes into the prosecution's case. What you normally see with the prosecution in their first closing argument, not their rebuttal, is a breakdown of the jury instructions, a breakdown of what the charges are, what evidence goes to those charges, and then you tell the story. Binger does a better job than any of these other lawyers at telling a story. But this kind of the pointing a gun at the jury loses that moment. The reason the defense didn't object is kind of twofold. Robert Barnes, who is a defense attorney was talking about this yesterday, I think on Viva Barnes, and made and I think the very astute observation that if the defense had objected, then it makes it look like what Binger is doing with this AR pointed at the jury is so bad that it needs to be objected to. But their position is that the gun alone is not provocation. So they really couldn't object to this. They have to let the DA seal his own fate. And there are definitely times we're sitting there going, what? What are you doing? Why isn't the defense objecting? But that is a that is a choice that the defense has to make on the spur of the moment, on the fly. They have to process all that information as the DA is doing this to see if you need to object or not. And I think they were right in letting the DA make his own bed and potentially lie in it with this. And I'm sure the defense is looking at the jury and seeing how they're responding to it. I'm going to try not to hit my mic. I'm sure that was loud, but seeing how they're responding to it. And lawyers are allowed to make choices like this in their closing. They're not always good choices, and I don't think it's going to go well. Let's talk about the um let's talk about the charges that the jury's going to have to decide. What happened yesterday after all the closing arguments? The jury was selected this morning. I really like the way Wisconsin does this. They put like, yeah, like a bingo cage of the numbers because each juror has a number. There's 18 of them. And then they bingo cage 6 of them, and those 6 become the alternates. So during the trial, you don't know as a juror sitting there if you're going to be a juror or an alternate. So you have to treat it as if you're going to be a deliberating juror, not an alternate, which I think keeps people more engaged. You can see alternates when they know they're alternates, like this, through like most of the trial. It's like, it doesn't even matter that I'm here. Like, I'm never going to deliberate this. So why does it matter? I think making sure that the jurors during the course of the trial are engaged is a huge thing and a huge benefit. So that I really like the way that they do that. I think that the defense closing, not my personal style. I think it will play well to the jury there. Um, I think there are things I would have liked to have seen the defense do, but there's things I would have liked to see the prosecution do, like not point a gun at the jury. So the real heart of this case breaks down to self-defense, obviously, and provocation. And self-defense, the reason they kept saying privilege in court and in their closing is because the self-defense is a privilege. Like if you have the right to self-defense, then the killings aren't killings, they become justifiable homicides because of self-defense. So that's why they kept saying the privilege of self-defense. I know that privilege has different meanings in different contexts, but in court, it means that it's a defense in the way that the Wisconsin law is written. So let's go through these charges. Um, yeah, and then I'll answer as we get to questions. I will answer questions on this and on Duggar. We have a lot of motions to cover. So I think the Associated Press News did a good job of breaking down these charges. So I'm just going through this, and I will absolutely share the link to this for y'all if you want to read it too. Trying to find news on this trial that is not skewed one way or the other has been an interesting challenge. So, thank you. It's my hair has gotten insane over the last year. I have not cut it much. It's getting a snip snip this week because the ends are let's not talk about the ends. The ends have gotten a little, I don't know. The ends have gotten a little crisp for sure. And my chat's just absolutely stopped. So I still see the chat in the chat. Let me slow this down just a oh, we're on slow mode as slow as we can go. So Mm, yep, my chats have stopped. So I hopefully will be able to see it again in a minute. I'm not going to restart StreamYard because then I'll get booted. So hopefully we'll all catch back up. So there we go. We're just going to keep going and hope for the best. So let's get into this. But I appreciate the AP. I will put a link down in the description below. I tried to send a link through my chat and it just didn't work at all. So whatevs. All right. Count one, first degree reckless homicide, use of a dangerous weapon. This is the charge to the death of Joseph Rosenbaum. Joseph Rosenbaum, from the prosecutor's perspective, was chased by Rittenhouse. From the defense perspective, chased Rittenhouse. They're saying that Rosenbaum, even though he threw a bag at Rittenhouse, was not really provocation and that Rittenhouse could have ran away better. The defense is saying that Rittenhouse got backed up to cars and a shot went off behind him and he thought he was being shot at. And then Rosenbaum lunged at him. Um, and that's when he was shot and killed. So this is a difference. Well, the videos show what the videos show. I think the videos show Rosenbaum chasing down Rittenhouse. They're saying the prosecution's theory is that Rittenhouse kind of provoked that by having the AR and by being there. And so that's why he was being chased, but he was the provoker of the instance. And if you provoke it, you don't have a right to self defense. But the prosecutors are alleging that um, Rittenhouse showed an utter disregard for human life. And that's where you get this reckless homicide, not intentional homicide, because you're not going to show that Rittenhouse went out there looking for Joseph Rosenbaum, intended to kill Joseph Rosenbaum, intended to do things that were aimed at killing Joseph Rosenbaum. So that's why you're getting this charge of recklessness, saying that his behavior was reckless. The defense is arguing no, he was being attacked. He only fired the shots that needed to be fired to stop the attack. And that's why it's not a reckless homicide by way of self defense. When we get to count number two, the charge is punishable by up to 60 years in prison. The dangerous weapon modifier carries an additional 5 years. So the fact that he was carrying a rifle carries an additional 5 years. And that's true in a lot. Most jurisdictions have their own gun enhancements depending on the type of gun, et cetera, et cetera. The next charge is first degree reckless endangering safety, use of a dangerous weapon. This is with regard to the Rosenbaum shooting because there was another person present, the witness McGinnis, who was standing in the vicinity of Rosenbaum when he was shot. I think this is a hard one to prove because there weren't you this wasn't a circumstance where you saw a barrage of bullets like like other cases where you see somebody just spraying bullets, and it's hard to talk about instances like that. But something like the Route 91 concert shooting where it's just, and I know, there was a shooting in Aurora, Colorado yesterday, which is also heartbreaking. So it's always hard to talk about shootings and talk about the law that is connected to them without bringing up, like, visceral reactions of other mass shootings. So that's when they're talking about recklessly endangering the safety, it's generally used where somebody is indiscriminately firing, not when somebody's firing directly. I don't think that's a strong charge. I haven't thought that that was a strong charge because even if a bullet misses the intended target center mass, it isn't a indiscriminate firing. So hopefully that makes sense on count two. I don't think count two is a particularly strong count. Count three is first degree reckless endangering of safety, use of a deadly weapon. This is with regard to the guy who they're calling jump kick man throughout the trial. I didn't pay attention to the initial 402s. I didn't really watch what was happening with the pretrial motions. I don't know why Jump Kick Man was the choice. I don't know why that was the name that he was given, but it was an odd thing for me to see that that's what he was referred to by both lawyers throughout the trial. It was just strange. Um so let us continue on with Jump Kick Man. I'm actually going to see if I can uh, figure out what's going on with this chat because my chat has completely shut down. And I'm going to let StreamYard know that my chat is completely shut down. Um, uh, because we're professionals here, people. It's what happens. All right. We're going to try to continue to stream smoothly while I can't see y'all commenting, but I'll be back to seeing y'all comment in a moment. So, first degree, wait, we did we're on count 3. The reckless endangering with regard to the unknown man leaping at Rittenhouse and trying to kick him seconds before Huber hits him with the skateboard. Rittenhouse appears to fire 2 rounds at the man but misses as the man runs away. So whether or not that is recklessly endangering, we will see. They will have to determine whether that individual who was jump kicking at him was a, imminent threat of grievous bodily harm, and whether you're allowed to use self-defense um in that case. So StreamYard is telling me that this is a known issue. Well, um, I will let the law nerds um, know that I can't see them. I'll just pull up the chat in another window in a moment as we get to questions. I might not be able to pull them up on the screen. So that great, of course. So that's count 3. Count 4, first-degree intentional homicide, use of a dangerous weapon. This is the charge with Huber's death. And I know that the judge ruled that people couldn't be called victims. I just think that no matter whether or not there's self-defense, and I understand why the judge ruled it, because if there's self-defense, then criminally it is a justifiable homicide. It is not a murder, which is a unlawful taking of somebody's life. So I understand the judge saying the word victim can be prejudicial in a case of self-defense. However, when people get shot, they are victims in my mind. And so I will fluctuate between the two because I'm not arguing to a jury. And I'm not going to persuade anyone with my thoughts because I'm not here to persuade. I'm here to explain. So you will hear me vacillate between the two, even though that's what the judge had ruled, and briefly why. And I'll answer questions on that when we get to Q&A if you would like. So this is regarding Huber's death. The video shows Rittenhouse running down the street after shooting Rosenbaum. When he falls, he doesn't really fall from the video. He gets hit in the back of the head, and then jump kick man actually connects with him based on the evidence as I watched it come out in court and based on the witness testimony. So, AP News, I think that he doesn't really fall to the street. He is struck in the back of the head and then is kicked in the face. But okay. Huber leaps at him and swings a skateboard at his head and neck. Um, he hits him in the head and neck with the skateboard based on the video. So it's not that he swings and misses, he actually hits him, and then he does grab, it says tries to grab. See, there is significant evidence that he had his hand on Rittenhouse's gun, and you can see the gun being pulled away from Rittenhouse's body before he fires. The criminal complaint alleges Rittenhouse aimed the weapon at Huber. He shot him. He absolutely aimed the weapon at him and shot and killed him. Of all the first degree cases, I think the one with regard to Huber is the strongest because Huber, by the markings on his hand and by all the testimony that came out from the medical examiner, all of this, all of that kind of indicates the defense's theory of the case. All the evidence with regard to Huber indicates the defense's theory of the case. So it's interesting to read how this is written, because if you didn't watch the testimony and we're just reading this AP News article, which I might think twice about sharing as we're getting into it, it doesn't indicate some of the moments that came out in the witness testimony and video testimony at trial that indicate why there is self-defense on some of these. And so if you're just reading this article going, okay, well, he falls down, sure, okay, he falls, and he has somebody swing a skateboard at him, but okay, so you're swinging a skateboard. It definitely paints a different picture than he's hit in the back of the head, knocked to the ground, kicked in the face, and then is hit in the head and neck with a skateboard. The two are fairly substantially different when we're talking about a self-defense case, and that's been some of my frustration with the media reporting on this because it is he was in, particularly in the Huber shooting, he was being attacked and someone was trying to take his gun, and that is self-defense. And I've charged more than a handful of assault with a deadly weapon where the deadly weapon was a skateboard because they can do substantial damage. So I realize that that's probably more common in California than it is in Wisconsin, but still, skateboards can do a substantial amount of damage. All right, count 5, attempted first degree intentional homicide, use of a deadly weapon. This is the first intentional homicide we saw charged. They're also charging lesser included crimes, which means you can pick the jury can pick the attempted first degree homicide, or the jury can pick a attempted reckless homicide. This is with regard to Gage Groskowitz, who is probably the most problematic witness for the prosecution. Groskowitz was shot in the arm after Huber was shot. When you watch that video, you see Groskowitz stop when Huber is shot and then come back in at Kyle Rittenhouse. But on cross examination, Groskowitz said that he was not shot by Rittenhouse until he pointed his gun at Rittenhouse's face. So again, I think that of all of the charges, this the Huber charge, I think, is a easier self-defense charge for the jury to find. The Groskowitz charge is also a fairly easy self-defense charge based on what the testimony was from Groskowitz, which was, when I had my hands up, Rittenhouse wasn't shooting, and then when I came forward with a, illegal Glock that he was carrying concealed, even though he didn't have a concealed carry permit, and pointing it in somebody's face, that somebody was going to shoot first in that circumstance, and it was either going to be Groskowitz or it was going to be Rittenhouse. So I think, again, the jury will probably find self-defense to that. Groskowitz was not killed. He was shot in the arm and injured. His testimony did more damage to himself. And then he went and gave a bunch of media interviews saying that his testimony on the stand wasn't accurate, which was odd to watch. I've never seen ever a witness testify in a case, the case not even be with the jury yet, and then that person go and give media interviews. It was just an odd and kind of surreal circumstance. Let us move on to count 6, which was dismissed by the judge. Rightly so, legally, in my opinion, even though I'm sure many disagree with that. But legally, I think it's the proper result. Possession of a dangerous weapon by a person under 18. The judge dismissed the charge on Monday. Did they say why? I guess they linked to another article. Rittenhouse was armed with an AR style semi automatic rifle. He was 17 years old the night of the shootings. Wisconsin law prohibits minors from possessing firearms except for hunting or when supervised by an adult in target practice. But there is a barrel length when it comes to this, and hunting rifles are accepted and lined out by the statute. The AR-15 is a rifle. It is not short barreled. Therefore, it does not fall under this law. They go on to say prosecutors argued the defense was misreading the statute. Schroeder had earlier twice declined to dismiss the charge, but that's the judge. But the judge also had said that the statute was confusing. After prosecutors conceded that the rifle was not short barreled, Schroeder dismissed the charge because the prosecutors knew that that's what the law said. So let me, StreamYard just messaged. So there is an outage and I'm just not going to be able to pull up chat. So I will pull up the chat in a separate window when I'm done covering these so I can see what you're saying. So thank you, mods, for holding it down. I appreciate it. I know that this is a difficult case, but if you've watched the testimony is the testimony, and the testimony that came out is the testimony that came out. So that was dismissed, and I believe the curfew charge was also dismissed because it was determined that the curfew was not legally implemented. So there is no illegal possession of the weapon, which changes the prosecution's argument with regard to provocation. Because the prosecution could argue, look, he illegally possessed this weapon, and therefore he was doing an illegal act that provoked the crowd in this circumstance, and that's why he was attacked, versus having to argue that the weapon itself was provocation, because they can't argue it was illegally possessed because the judge dismissed that charge. I agree with the judge's reading of the statute. I don't think the statute's great, but the prosecution did not prove that the AR rifle was a short barreled rifle that fell under the definition of the law. That was on them to do. They didn't do it. And I don't think the AR is going to count because it's not a short barreled rifle. So the reason short barreled rifles are generally treated different under the laws because they're more concealable. That's the general thought. But I also worked in a state where you couldn't have an AR. So this never really came up in Southern California. It was pretty cut and dry. If you have an AR, it's an illegal weapon in California. So the analysis stops there. It is different in states where open carry is permitted. Wisconsin allowing you to openly carry weapons. What's interesting is that the prosecution didn't charge Gage Groskowitz with illegally carrying a concealed handgun, but that's all right. It just, what do we expect? If they charge him, then he can't testify for them. And that's what it is. Sorry. StreamYard. This is going to be an interesting day if all the streams are down because all of us use StreamYard. So that is that is the counts. So the lesser included, the jury gets to decide. The jury gets to decide if the charges are, even if they find like yes there was a shooting, which is not in question here. There were shootings. There's no question that the two victims that were shot were killed. There's no question that Gage Groskowitz was shot and injured. Those aren't in question. It's whether it was justified by self-defense based on the circumstances, and the jury determines what the facts are. The prosecution and defense has their theories, but the jury gets to decide these are the facts. This is what we see on the video. This is what we heard in the testimony. And if they decide that Kyle Rittenhouse was in a circumstance where he was justified in using self-defense, justified in using deadly force against the force that was coming at him, then he's going to be not guilty. If they decide that he either used imperfect self-defense, meaning he was at the right to defend himself, but the force he used was too great, which is what the rebuttal prosecutor was trying to argue, but was so pissed off at the defense that he couldn't articulate himself very well in closing, that he couldn't really get there because there is lesser included of imperfect self-defense. So if he used too much force, then it's a lower charge because yes, he had the right to use self-defense, but he used more force than was warranted. I think with Gage Groskowitz, that's going to be the easiest analysis for the jury because Gage was pointing a gun in his face and he used a weapon in response. It is a little easier with the skateboard. It becomes harder in the first situation with Huber, who had thrown a bag at him. No one knows what's in the bag. It was never recovered. But there was a shot that went off behind Kyle. And it seems that the defense is arguing he didn't know if he was being shot at and kind of spun around and then fired at somebody lunging at him. So I think of all the different incidents, the first incident with Rosenbaum becomes the most difficult for the jury. The others are a little more clear, but this jury can convict on one charge of the lesser included. So this jury can convict on no charges. This jury, I would be surprised if they convicted on all charges without self-defense. Like that would probably be the most surprising result to me. I just don't see that happening based on the facts that came in evidence. The jury could also hang, and a jury has to decide unanimously, all 12 of them, that this is either self-defense or not self-defense is really the question. And if Kyle provoked a circumstance, then he doesn't have the right to self-defense, and they have to have those conversations too. I don't think this is as easy for a jury as some may think. I disagree that this jury is going to come back quickly, but it's already noon, and I will check the news before we're done streaming and see if we have any indication of what they're doing. I think that juries weigh heavy when life has been lost, even if it's self-defense, and they're going to talk through each of these incidents. They're going to talk through what they saw in the testimony and the video, and I think they're going to take their duty very seriously. They're also members of the community in Kenosha that are going to remember what it was like in Kenosha, and they're going to have watched that video over and over and over and decide if Kyle provoked things and brought them on himself, or if he was attacked and had the right to use self-defense. but the prosecution can't argue and the jury can't consider that him just being there was provocation enough. It has to be more than that. So, uh, I think to me, it's undisputable that he shouldn't have been there. This was not a situation where he was going to be able to do anything to help. Things had gotten out of hand in the nights before, and I don't know how you. I don't know. He's a 17-year-old that made a really, really bad choice about being out there. Whether the choices after that were justified or not, a jury's going to decide. Do I still think a hung jury is a possibility? Yes, I do. I absolutely think a hung jury is a possibility. So I think the defense in their closing, and I'm gonna move on to Duggar stuff. I think the defense, um, I think the defense was really right in pointing out that no one wins in this case. Like, this case is lost all the way round. People lost their lives. Kyle Rittenhouse is going to also lose the life he might have thought he had, unless he moves and changes his name, and even then, there is no living this down. There is no escaping what happened, and I really do genuinely believe that Rittenhouse is suffering from PTSD. I can't imagine that he wouldn't be. Um, so, I don't think he was acting on the stand. I really don't, just from watching it, and after watching a lot of people testify based on my experience. I think that having to talk about the incident that night and talk about the fact that he took the lives of 2 people weighs heavy on him. I really do. But also shouldn't have been there, but the jury's not going to get to decide that. So, if a hung jury, does happen, the judge can dismiss the case, um, but we will see what happens with that. It depends on the hang too. They'll pull the jury. If it is one person holding out for from an acquittal, the prosecution might not choose to retry the case. I don't think this prosecution team would make that choice, even if they should. Um, so we will see. I think there's been a lot made of this case from people who haven't watched all the evidence of this case. I think this case is heartbreaking. I think the judge has been very fair. I think the judge has um definitely gave it to the prosecutor. The judge could have declared this a mistrial with the prosecution's Fifth Amendment violation and chose not to. Um there are other things the judge could have done that were more heavy-handed against the prosecution and chose not to. I think the judge was lenient with the prosecution. He definitely screamed at them, but he didn't take action against them, even when the prosecution elicited things that weren't in evidence during their rebuttal, which I also was pissed about. So that's where we're at with this. We will see. I will break down the verdict, whichever way the verdict goes, and I generally believe that a lot of the time juries get it right. I will break down the verdict when it comes down. So if you're following me on social media at the Emily D. Baker, go ahead and do that. I will break it down, and then we'll discuss it at the next live. So that's what it is. Um, let us let us continue on. I know this trial is absolutely polarizing, but people have their own perspectives on it. So, I see a question about the case being dismissed. Some of the charges were dismissed. The illegal possession of the weapons charge was dismissed, which was a misdemeanor, and the failure to comply with an emergency order was dismissed. So, I think the thing that the defense should have fought harder on was the provocation instruction, and should have tried to not allow the prosecution to argue provocation. I don't think that was ever going to happen. They just kind of rolled over on it. So let us move on to Duggar. I know when Duggar is less polarizing, you know that we are going, you know that we've been talking about some polarizing topic. When it's like, can we talk about something lighter like Josh Duggar? It's like, fuck, what is our life today? Like, what is our stream today when that's what we're when that's what we're talking about. Um, so let's get to that. Um, I gotta swoop, I gotta change my notes. Oh, y'all are back. I have a chat again. I have a chat. I have a chat. I have a chat. All right. Let's swoop um and get into all of these motions. We're going to do a quick road so far and then all the swoop. There's so many motions in the Duggar case. Josh Duggar is charged with possession of and receiving CP. I call it CP because it is what the charge is. The charge is possession of and receipt of CP. Um, but I know there are many that take issue with the term CP. That is still what the law calls it, but they are also um, child sexual abuse images. That is a much longer acronym that is much more difficult for me to say. So know when we talk about CP that's what we're talking about. I'm sure our stream is already demonetized because we're talking about Duggar, but it is what it is. So we are going to be talking about the motions before trial. He is set to start trial November 30th. That means they will start jury selection or should start jury selection that day. I don't know if they're going to send out juror questionnaires. They might have to because, again, the Duggar family is known in that community. So they're going to have to make sure they're selecting jurors who don't know the Josh Duggar or his family, which there's a lot of his family. So um, there's going to be a lot of need there to poll the jury to not poll the jury to questionnaire the jury and make sure that there aren't jurors coming in who know this. So that's what it is. That's what it is. So let us talk about what's going on pre-trial. There have been numerous excuse me. All right, we're back. There are lots of motions in Limine. These are the motions before before the trial goes to trial. When you saw in the Rittenhouse case the judge unload on the prosecutor for getting into an area that had been ruled on in pretrial motions, that's the same thing that's happening here. That there are pretrial motions where they're trying to determine what evidence comes in, what evidence doesn't come in, and how that works. So they are arguing over a lot of things. The government has made um four motions in Limine. The four motions are regarding the trademark markings on the HP computer, the prior statements, the third-party guilt, and prior acts. We're going to talk about each of those really briefly because then we're going to get into the defense response to those. And then the defense made numerous motions, one, two, three, six motions, regarding the production of documents, excluding opinion testimony, excluding evidence of adultery, the Ashley Madison stuff, excluding the Ashley Madison stuff, and any comments about an addiction to adult porn. Spelled out for the benefit of the algorithm. Thank you, YouTube. We're trying to educate and cover court documents. I get it. um, to exclude the juvenile allegations with regard to assault of minors, um, with regard to sequestering witnesses, and then questions that Duggar declined to answer. I went through all of these motions in another video that I will link. So if you guys want to go through the initial motions, I will link those. I'm going to go through the responses today. I will touch on what the prior motion said as it relates to the response. So hopefully that makes sense. Let's do it. We're gonna just do it. Let's start with the government motions. Do you agree? Let's start with we're gonna start with the non-sensitive topics and then move on to some of the more difficult topics. So, and then these motions in limine are being heard. Let me see. I totally forgot to write it down. I will look. They should be coming up soon because these responses were filed last week. So the date to hear the motions in limine should be coming up soon. So let me just double check that because I saw a question in the chat. See, the chat's back. You can see how much more distracted that I get before we get into all of this. I'm going to just drink coffee as I'm pulling up Pacer because my coffee's still not done and it's delicious. And after this, I might go get other coffee. We might need more coffee. Let's see. These were filed November 12th. That's a little tight. Let me see when let me just run when the next hearing date is real quick. Things we should have done, but we're doing now. Deadlines and hearings. All right. Let's see. Pretrial conference set for doesn't have it. 11/18. So when's that? Thursday? So Thursday is when the next pretrial conference is, and that's when they're going to decide the motions in limine. Excuse me. The trial is set for the 30th. That's when they'll start jury selection, which shouldn't take too long in federal cases. If they do a jury questionnaire, it shouldn't take too long. So let us start with the government motions with regard to the trademarks. Let's get into the defense response. This is really just just a I don't know why they're fighting over this. This is just being able to say the HP computer is an HP computer without bringing in someone from HP to say it's an HP. Like it's just let's see what the defense has to say. The writing though has been very, very clear, and I appreciate that. So, defendant Joshua James Duggar, by and through undersigned counsel, the government argues, brings this motion. The government response. The government argues that trade inscription purportedly affixed. They said purportedly affixed to the HP desktop computer seized from Wholesale Motors on November 8th is self-authenticating pursuant to FRE 9027. Duggar agrees with the government's position on that issue. Yay! Woohoo! I'm so glad. I'm so glad. This makes so much sense. This makes a lot of sense. So let us move on to agreement. Repeatedly, the government argues that the trade inscription does not constitute hearsay because the trade inscription is simply part of the physical evidence of the case. Why do you need to write more? Based on the foregoing, Duggar respectfully requests that the court withhold any ruling on the admissibility of trademark inscription until it is offered at trial, but Duggar does not oppose a pretrial ruling by this court that the trademark inscription on the HP computer is self-authenticating non-hearsay. Oh, thank God. And that's exactly what the court is going to do. Look, sometimes it's nice just to see the defense go, it is self-authenticating. And I know a lot of you are like, why does this even need to happen? Because of foundation. Now, if you've watched the Rittenhouse trial, they kind of ignore the fact that foundation exists, but foundation exists. You have to prove that a thing is a thing. So if you're bringing in a computer that is an HP desktop, you have to prove that it's an HP desktop. And instead of having to bring somebody in from HP, you can show like oh, you can't see it. I was going to say my phone has a little apple there. So I can prove that the little apple there means my phone's an Apple without having to bring in someone from Apple to identify the phone as an Apple. Because generally that would be something that is not a fact until it's testified to. Can we talk about this case? I love this case from Casetify, by the way. Anyway. If you guys are like, Emily, you have sponsored things. Do you use them? Yes. Yes, I do. I got distracted by showing my phone to try to make a point, but the thing speaks for itself, right? The thing is the thing. We're moving on. You're all like, okay, we get it. An HP is an HP is an HP. Good. Let's go to third party guilt because again, it's not triggering. I mean, the whole Duggar case is triggering, like the whole thing. These cases are just, they're ick. It's just like, bleh. But we're going to go to the least to the most. I really like the way that the defense summarized the prosecution or the government's argument while actually properly citing it. What you get sometimes when when defense attorneys and prosecutors are fighting is that the defense will say the prosecution's asking for, DEF, when what the prosecution asked for was ABC and the defense has spun the argument, very much the way politicians do when they get asked a question and they bridge it so that the answer is not really the answer to the question that was asked, but it's the answer they wanted to give anyway. So they kind of manipulate the question. And I'm not seeing that here yet, and I appreciate that we're not seeing that here yet. This is the defense response to in opposition to the government's motion to exclude third-party guilt evidence. The government argued that the defense is blocked from bringing in, like, some other dude did it without having a foundational connection between the two, because you have to legally have um a foundational connection between the two. You can't just say anybody could have just walked in off the street and done the thing. There has to be a connection, like this person had the opportunity, this person had the motive, this person had the thing. So, let us um the defense is arguing that based on the controlling law and evidence, this court should deny the government's motion to the government is trying to stop the defense from bringing in this evidence without proving the link between the two. The defense goes on to object, saying on a more fundamental level, this court should see the government's motion for what it is, an attempt to prevent Duggar from highlighting the existence of reasonable doubt by establishing that other people had access and opportunity to commit the acts at issue, by emphasizing that law enforcement failed to effectively investigate these crimes. I don't think that's what the government's trying to do. The government can't do that. The government needs to the government's not wrong to ask that there's a connection between the two. I don't think this motion will get denied. I think this motion will get split where the court's going to be like, no, if you're going to offer some other dude did it, you have to show us how. But the defense will be allowed to argue other people had access, but the government didn't thoroughly investigate it. That's a valid argument. And really, that's all the defense. I mean, the defense has to try to put not just some other person at the computer, but put doubt that Duggar was the one at the computer. That's what they have to do in this trial. The United States Constitution guarantees all criminal defendants a meaningful opportunity to present a complete defense. Let's see if they actually address what the government argued. Um, Duggar is charged in a two-count indictment. We know the government's case. This is the defense um, perception. The government case boils down to an allegation that cached thumbnails of CP were found on an HP desktop computer accessible to and used by many people at a business. Yeah. Okay. Here's what the government, well, I'm not going to argue the government side for them, but I will. I'm not going to, but I will for just a minute. But what the government has to prove is why no one else had access to the partitioned part of the computer where this was found. And they're going to do that through the passwords. And the passwords that Duggar used based on the testimony at the detention hearing were the same passwords used on a bank account and on social media accounts. So, would your employees at a car lot have the password that you also use to access your bank account? And that's what the government's going to argue to the jury. So, even if the defense argues, which they will and should, it's their job, somebody else could have accessed the computer. The government's going to be like, but somebody else didn't have the password, because we also have statements from Duggar saying, I trusted too many felons. Well, if you're worried that you trusted too many felons, would you give them the password to your bank account? I'm going to go with a big negative, Ghost Rider. So that's why we're seeing the person he made that statement to. I'm summarizing, but like I'm in this because I trusted too many felons. That person's now being subpoenaed, and that subpoena was, well, we'll pull that up when we get to the end of these. So that's what's going on. They say the defense will establish at trial that Duggar's personal devices seized during the government's investigation include a MacBook Pro laptop, an Apple iPhone, did not even have a forensic trace of CP. They also had the Covenant Eyes program on them. So, you know, um, Phoenix said, I trusted too many felons. What does that even mean? It's in the government's last documents about this where he made that statement. I think it's, again, him trying to say other people, some other dude did it because somebody else had access to the computer. They say that computer forensics will play a significant role in this trial. Yes. Um, Also, the Apple devices are much harder to partition, so I'm not surprised it's the work computer that's not checked by his wife that's partitioned all arguments the government will be making to a jury. Against this backdrop, discovery provided by the government reveals that law enforcement chose not to forensically image electronic devices belonging to several people who had access to the business computer at issue. Those witnesses include William Mays and Randall Berry. Remember that the government's evidence on this is that those individuals did not work at the car lot when this happened. Um, can you partition a Mac? You can partition a Mac, but it just wasn't done in this case. Yes, I know you can partition a Mac. It's not the same as partitioning the HP and the Mac. Well, the HP also had Covenant eyes on it, but the Mac was his personal computer that was going back and forth because it was a laptop, which would be easier to access and look at versus the work computer. And so I think that's what their argument will be. Um, so in pretrial motions, Duggar argued that law enforcement's failure to perform forensic examinations of those devices and to preserve that evidence warranted a dismissal, and the court said, "Yeet that argument right out of my court. The evidence will." That's vernacular for it was denied. The evidence will establish that Mays was regularly present on the car lot and at least one occasion unlawfully entered the office where the HP was without Duggar's knowledge or consent. Oh, unlawfully entered the office. Okay. The evidence will also establish that Berry firmly and confidentially told law enforcement that he did not even meet Duggar until June 11th, but then walked back that statement after a financial record introduced at the evidentiary hearing before this court established that he was paid for work at the car lot in May. And those are all valid arguments that they will be able to make. Look, this guy distanced himself too much, blah, 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 blah. Gail, yes, I am going to talk about the witness that they are trying to bring in. Yes. At the end of this, I will bring up that habeas petition. They then go on to say, this is great. Look, here's why this motion's great. We get to see what the defense's argument is. This is the defense laying out their defense. This is the defense case. This is the defense theory of the case. This is the defense saying we're going to use these witnesses to show these things. This is what we know. So we get a peek at the defense case. We've seen a lot of the government's case. So the more you know, the more you know. All right, let us continue on. Based on further investigation, the government now asserts that Berry did not start working at the business until late May 2019 after the alleged crimes occurred, and that Mays was in a Walmart in Ozark, Missouri on May 15th. In the government's view, the evidence suggests these people were not at the car lot at the times in question, and Duggar should therefore be prohibited from offering any evidence suggesting a contrary conclusion, but the facts are very much in dispute. And I think the judge in this instance will say on this motion, let the facts come out. And once the facts come out, then they can readdress this motion. So let the government put on their case, see what the facts come out in their case, and then we will readdress this. So they might not rule on this immediately. This might be taken under submission until the evidence is done in the prosecution's case. In a criminal trial, you get jury selection, opening statements. You're not supposed to argue in the opening. That's why it's not opening arguments, opening statements. Then you get the prosecution's case in chief where they bring their witnesses and prove their case or try to prove their case. Then the defense case. But when the prosecution rests, there should be time to reevaluate some of these motions before the defense brings in evidence or before they elicit it. And that's why the prosecution got yelled at in Rittenhouse, because they were trying to get into territory that the judge had cordoned off, and they didn't readdress it with the judge and say, I think the door's been opened. That in federal court, the judge would have blown up, I think, more than the judge blew up in the Rittenhouse case. It would just it I can't imagine that happening in federal court. I can't imagine federal prosecutors doing that. So they then go on to say evidence in the government's possession, custody, or control since November 8th clearly establishes that Barry had dealings at the car lot at the latest on May 16th, 2019, which falls squarely within the timeframe alleged in the indictment. And at a minimum, Barry's recollection of the dates has proven to be remarkably unreliable. So, this, because there's a dispute, in fact, I think the court will say, let's see what this witness has to say, and then we'll go from there. Because this doesn't have to be decided pre-trial. The defense just couldn't argue it in their opening or argue it, state it in their opening statements, but the defense can reserve their opening statements and not make their opening statements until before their case, which is really interesting to me when defense attorneys don't do that. But it's a strategy call because the prosecution can make an opening statement, the evidence will show blah, and then they show the evidence. And then the defense can make an opening statement at the beginning of their case saying the defense will show. They can reserve it. They don't have to make it at the beginning. Not a lot do. That's a strategy thing. So let us continue. They said, with respect to Mays, who has regularly frequented the car lot and has historically broken into the office without Duggar's knowledge or consent, I wonder what the proof is of that. Because frequently, historically broken into the office is interesting. A credit card transaction at a Walmart in a single day is hardly determinative. In fact, the alleged criminal activity on May 15th occurred during two discrete times, and contrary to the government's view of the evidence, did not actually require someone to be physically seated at the desktop to orchestrate the computer activity. I wonder how they're going to prove that. That will be interesting. That will be very interesting. So, is the defense going to try to show that somebody remotely accessed the computer? Huh, interesting. They say Duggar does not seek to pre-litigate the facts in this case by opposing a prosecution motion in limine, nor should he be required to do so. But suffice to say, the parties adamantly disagree about the facts. Duggar has a right to have a jury decide the facts. Even beyond Barry and Mays, the government's motion takes a troubling step further. The government asks the court to preclude Duggar from presenting evidence or argument that anyone else other than Duggar may have had the opportunity or ability to have committed these crimes. I don't see it as nefariously, but again, the defense is going to argue things the most strong light towards them. And so I get what they're arguing, but the court cannot and will not limit them from making any argument that someone else had the opportunity. The government is saying they need to show the connection between the two. So we will see what happens. Yeah, we will see what happens with this. The discussion is just them remaking those arguments, arguing the law. The court should not consider its previous ruling. The government effectively asked the court to reconsider its previous ruling that Duggar would be permitted to thoroughly cross-examine law enforcement witnesses concerning their failure to adequately investigate the possibility that someone else may have committed these crimes. So it's I'll be interested to see the judge's ruling on this one and what boundaries the judge sets around this. But some of these things are going to have to be fluid as the evidence comes out as the trial begins. But the defense makes good arguments. The defense makes the arguments they need to make. And I think that the defense is going to have to prove those points on cross examination before the court rules all the way. Because what the defense can't do is say, see, it could have been anybody. They have to have some tangibility. And now we have new facts. I love that we have new facts. The new facts are that somebody has broken into the office to use the computer. How they prove that will be very interesting. So, yep, that. And the footnote, the last footnote here is that the computer allegedly containing the CP belonged to the business. None of Duggar's personal devices contained evidence of any illegality whatsoever. So that's going to be their argument. The government's going to turn around and be like, yeah, because those devices go home. Probably not with that face, though. I can't imagine federal prosecutors making that exact face. All right, let's get into the next motion. Oh, what should we do next? That's third party guilt, prior acts, or prior statements. I think prior statements. We'll go to prior statements first and then we'll go to prior acts. Prior acts being one of the more difficult ones to talk about it. So let us just, all right. I'm going to try to see if I can make this there we go. Too big. Defendant's response to admit prior statements by defendant. The government's motion boils down to this. In 2015, Duggar allegedly stated he had an addiction to viewing adult porn in a press release attributed to Duggar posted on the Duggar family website. It's so interesting because he talked about it, I think, more than that. But they're saying what what is what is stated what is stated on the family website is not necessarily attributable to him, even if they're talking about what's attributable to him. Interesting. They say viewing adult pornography somehow constitutes wrongful conduct or a prior bad act, even though adult pornography is protected under the First Amendment. And Duggar's alleged statement is somehow probative of whether he possessed or received CP on or about May 14th and May 16th. This court should reject the government's position. They go on to say, first, the statement, even if it can be attributed to Duggar as non hearsay, is not relevant and is therefore inadmissible. Second, if this court were to conclude that the statement has some minimal relevance, any such probative value is substantially outweighed by the danger of unfair prejudice and confusion, and the statement should therefore be excluded under FRE 403. Third, contrary to the government's unsupported characterization, the statement does not reflect wrongful conduct and is not admissible as a prior bad act in the United States, where viewing adult PORN is generally constitutionally protected. True. Indeed, at its core, the government's motion is ultimately predicated on the misguided suggestion that a purported interest in viewing adult PORN is somehow probative of whether a person knowingly received or possessed child PORN 4 years later. Okay. Well, all right. Um, the government argued that it was probative as to identity and knowledge, and I don't think it's relevant yet. Um, Here's why I don't think it's relevant yet. Evidence would have to make this relevant based on what is said. The government is trying to probe this area or try to gauge the court's ruling in this area in case the argument from Duggar's lawyers are he didn't have any knowledge of this, he didn't have any intention of this, he didn't have any predilection. And they're trying to say, well, look, he's admitted to an addiction in this area. So you can't say that you don't know or that you would never look at PORN. So it's going to constrain, I think this will end up constraining the way that the defense argues thing to not open the door to get into this. I think that this isn't relevant on its face. Something would have to open the door for this to become relevant. And I think this is the government kind of indicating to the defense, look, you've got to curtail your arguments here so that you don't open the door so the government knows where those boundaries are to bring it in. So um, I saw someone ask a question, Allison, why are the mods so strict about staying on current topic? What if someone had a question about a prior topic? Allison, when we get to questions, I will ask them. We try to make sure that the chat stays on the topic that we're talking about because we have heard from many of our community members. It gets very confusing when there's a chats about like 7 different things. So we try to talk about the one topic, talk about the next topic, and then get to questions at the end. And that is at my request so that the chat flows and so that I don't get distracted because I'm ADHD and pulled back because I do like to be able to engage with the chat. And it's one of the things that helps me. So thank you. Winlux asked, I'm confused because this is the DA for are no we're oh, Wink Lux, you might be behind might be behind in the stream. So, and that is the other thing, some are behind in the stream and not caught up with where we're at on the stream, and that's what happens too. So, we try to keep moving on. So, yep. All right. Let us continue on with this. Y'all, Susie, you're like, we need Fred. Fred has been very active and engaged on my desk, but it's gonna be interesting because Fred likes to climb on my new soundboard. So, it's going to be interesting for sure. So, a huge thank you to the mods. All right, let us continue. As I've side noted the prior statements, I think this will be taken under advisement and will be addressed to curtail the arguments so that the attorneys know the bounds of what would open the door for this. The court should deny the government's request for a pretrial ruling deeming the admissibility of certain prior statements because it's clearly irrelevant. Again, I'm not going to get into the rest of this. We went through these motions pretty thoroughly. I think this is not quite timely, and the court will set some parameters but not rule on this necessarily, because it has to become relevant and something has to make it relevant. It's not relevant on its face. Let us get to, because we're an hour and 40 minutes in and we have multiple other things to go. Oh, this, they do make a prejudicial argument, and evidence has to be more probative than prejudicial, meaning it helps more than it hurts the defendant, and it also has to be relevant. I don't think we've crossed the relevant threshold yet, but the government plainly fails to pass the relevancy threshold yet. Moreover, the government does not acknowledge the inescapable fact that admission of this statement would result in unfair prejudice, confuse the issues, and mislead the jury. They then say that some jurors will hold strong opinions about adult PORN. They need to go ahead and evaluate that in jury selection. If you have jurors that hate any PORN, the defense is not going to want them on this jury because, um, yeah, that's going to be a tough one. That's going to be tough if they have jurors that are very personally opposed to legal and permissible adult content. And they say that that can arise out of personal, moral, or religious beliefs. As such, if a jury is permitted to hear that Duggar allegedly had a supposed addiction to viewing adult um, content, the danger is unfair. The danger of unfair prejudice is real. I mean, the charges are what the charges are. I don't think an addiction to adult content is going to be worse than what the charges are, because the charges are the charges. The court's going to read the indictment to the jurors. The charges are the charges, but I don't think it's relevant yet. And I think that the court will hold off on this. All right, let's get to the, let's see. The statement does not constitute wrongful conduct. I agree with that. They're going to try to use it for identity, motive, opportunity, knowledge. Like, I don't even know how to view that kind of stuff on a computer, those kinds of arguments. It's like, well, let's see. Um, the statement's not admissible under 404. That's a short argument. The government had a very long argument about this. They say that the government curiously argues that the statement is admissible under 404B as it provides, I should have just kept reading, motive, intent, knowledge, identity. Melanie, I'm going to get to that point in just a second. However, this position is belied by the government's concession that a publicly stated addiction to porn is akin to a statement of habit as opposed to a prior bad act. The government correctly acknowledges that under 404B, it bars the admission of defendants' other crimes. And Melanie in the chat makes a great point that, yes, they didn't address that at all in the defense motion. The government says they want it really for completeness to explain why Covenant Eyes, why Covenant Eyes is on this computer. And I think there's a way to do that without saying, oh, and by the way, he made a statement saying he had an addiction. So we will see. We will see. We will see what the court does. I think the court will put parameters on this. So thank you for bringing that question up. All right. Yeah. Let's see. You guys are like, should have keep reading. Always, always should have keep because I'm like explaining it and then they have it in their motion because lawyer brain, because lawyer brain, because lawyer brain. All right, let's get into prior acts. Look, for those of you following this story closely, just know that the prior acts alleged are awful. They involve very young minors, they involve hands on molestation, and that can be triggering for some. So, if it is, I will timestamp below when we move on to the other motions, but just know that that's what we're going to talk about. I tend to sanitize the details of this quite a bit. Um, and so I'm not going to be getting into, I don't know how much detail the defense will get into. The prosecution got into quite a bit of detail in their motion. So let us just get into the defense response. The defense doesn't want this in at all. Like at all. All. So this for the defense of the four government motions, this one is the most significant to them. And that's because this one is potentially the most damning. Defendant's response in opposition to the government's motion in limine to admit evidence of the defendant's prior child molestation conduct. All right. At its core, the government seeks to turn a trial about whether Duggar knowingly received or possessed CP into a during a 3-day period in May 2019 into a series of mini trials concerning whether Duggar violated Arkansas law approximately 18 years ago when he was a child. Interesting that they didn't use the word minor. When he was a minor, despite never being charged or convicted, the government motion should be denied for at least 5 independent reasons. Well, we've got a list. Let's move on to the list, any of which alone necessitates a denial, which collectively speaks volumes. Okay. First, to grant the relief the government seeks will create the need for mistrials concerning conduct that allegedly occurred, or mini trials. Me misspeaking. First, to grant the relief the government seeks will create the need for mini trials concerning the allegedly conduct that allegedly occurred nearly 2 decades ago to determine whether the conduct actually occurred and whether the conduct constituted uh, uh, ch- child harm for the purposes of Federal Rule of Evidence 414. Well, that's why they're bringing the pretrial motions so that they can determine some of those things before this goes to trial. This is tenuous ground. This is tenuous ground for the government, and I don't know if the I don't know how that will go because this is tenuous ground. So, third, second, the government has failed to comply with Rule 404B's disclosure requirements as it has not provided Duggar witness statements or a summary of expected testimony with respect to the conduct that allegedly occurred 20 years ago. I don't know the date when they have to do that by, but yes, they have to do that. So, yes, for sure. Third, while Rule 414 theoretically permits the introduction of evidence related to prior acts, well, they're conceding on that, which is interesting to me. That's interesting. Well, 414 theoretically permits the introduction of evidence related to prior acts of child harm. If this court were to theoretically conclude that the alleged prior acts occurred and that the alleged conduct constituted child harm and the government has complied with its disclosure requirements related to the prior acts, this court must still conclude that an analysis pursuant to 403 to determine whether any minimal probative value of the evidence is substantially outweighed by a danger of unfair prejudice, confusion, or risk of misleading the jury. They're saying because such dangers do substantially outweigh the probative value, and that is really what the court is going to have to deal with is that evidence of those acts when Duggar was a minor more prejudicial, meaning the jury could be like, you know what, fuck this guy. We're not doing that. And it doesn't matter if he had what he had now because of the past things, fuck you. So whether or not that's more likely to happen or not is going to be very interesting to see what the jury does. So, um, yeah, that's going to be very interesting. So, um, I think that this is going to be the most lengthy oral arguments, and I also don't know if we're gonna get a ruling on this before trial because this might be the circumstance where the court's just like, "You know what? Um, we're going to let the government's evidence come in their case in chief and see if the door's opened," or they might say, "No, it's not admissible unless this, and that." They might order disclosure. There's a lot of ways this motion can go. This is the one that's really the most harmful to defense, or potentially the most harmful and damaging to defense. But if the defense is going to put up somebody else did it, um, somebody else had the opportunity, somebody else had the motive, it wasn't us. This can lean towards showing, yes, but there's a reason you might have partitioned a computer, sought this out, gone through lengths to hide it. There's a reason for that. So it's interesting because I can see this one really going both ways. I can see it being ruled more hello, Fred. I can see it being ruled more prejudicial, but I can also see why the government might have a case for look, if they're going to argue somebody else did the things, you've got to be on this side, big cat. Big cat, you got to be over here. Hi. Thank you. So you don't step on my stone. Fred has gotten so big. Oh, there's a squirrel out there. That's why you're in here. I thought it was just to hang out with me. Um, so I can see the door being opened for it. If the defense wants to argue third party culpability, the government can argue, but there's a reason it's more likely him. And this would be part of the reason it's more likely him. So there we go. Fred, stepping on the things, stepping on the things. All right, let us continue on. Um, Relevant background, we know. Let's see. Further, it appears that the only reason this particular report is in the government's possession is because it was unlawfully leaked to the media several years ago. Well, then they should have sued over that. Specifically, in May 2015, the law firm purporting to represent a magazine filed a FOIA request, Freedom of Information. Oh, sorry. Fred's like, stop it. Stop holding me down, mom. Uh, The report was made a part of the disclosures to the magazine as part of the FOIA request. However, under Arkansas law, this was not permitted. We know that it's going to be interesting to see what the court does with that. Nobody's denying that. However, it's not, this court need not resolve the legality of the release. Well, because they have it now. This court should deny the government's motion. They go into the reasons again in more detail. I think the probative prejudicial argument is going to come up. I think that if the defense is going to argue somebody else, it might open the door for the government to say, but this is why maybe you, or this is why we think it's you. So I think we're through the defense responses. Yes, we are. All right. Now we've got to go through the government responses. Yay. All right. I said I would swoop to the government responses. So let's swoop at 1 hour and 53 minutes. The mods are like, I thought we streamed for 2 hours. I know. Sometimes we do. Sometimes we don't, because I do want to get to questions today too. Government responses to the defense motion in Limine. I'm going to do it the same way I did. We're going to go with the stuff that's more practical, tactical, procedural, and then we will get to the stuff that is a little more sensitive. So production of documents is the first motion that we're going to pull up that the government responded to. The defense is asking that the employment records and stuff turned over to the government not be attributed to Duggar, even though he's the record holder for the business. I think they're trying to say they don't want to prove like, oh, the defense, even Duggar showed us this and that. I think they can just stipulate to this. I'm interested to see what the government responds, because this is easy to stipulate that these documents are accurate records of the business. Like y'all can just, for sure. So let's see. Background, we know what the background is. In April 2020, during the pendency of its investigation, the grand jury issued a subpoena to Firestone Group LLC, DBA Wholesale Motors. The subpoena sought the following records. This is the first time we get to know this. I love this. Any and all records for wholesale motor cars pertaining to employees or contractors of the business. Here's what we've learned. Sorry, I'm going to back up. The grand jury that was investigating this wanted more information. So the grand jury decided, not the AUSAs. The grand jury said, we've seen your evidence. What we'd like to know is who else was at the car lot. The grand jury is an investigative arm and can issue subpoenas for information. The grand jury can say, look, we want to know who else was working there. I think it's really interesting that this evidence came from the grand jury subpoena and not from a law enforcement subpoena, because they, as a grand jury, were really looking at other alternatives and looking at other defenses. At a grand jury, there's no defendant at the table. There's no defense attorney. There's just the prosecution and their evidence. And the grand jury's allowed to evaluate all sides of a thing. I think that's really interesting. And we haven't seen that is how this came about yet until now. So interesting. Any and all records for wholesale motor cars pertaining to employees and or contractors of the business wholesale motor cars for the time period January 2019 through December 31st, 2019. Records should include but are not limited to. Sorry, I just had a thought and we're going to get to it after. I'm like, do I interrupt or do I finish reading? I'm going to finish reading and then I'm going to get to my thought. Employees and or contract employees hired, whether full-time or part-time, applications for employment contracts or performance, 1099s issued, name, social security, blah, 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 all this stuff. This means that the lawyers for Duggar, the subpoena was issued attention of Travis Story, who was the registered agent for Firestone, as indicated by the records maintained by the Arkansas Secretary of State and publicly available. They knew then that when this grand jury issued a subpoena in April 2020, that this was on its way. So when you get a grand jury subpoena, a grand jury is investigating you. So before the arrest in April 2020, there was a really significant heads up that the grand jury was investigating Duggar's behavior. He already had a heads up because there had been a raid at the wholesale motors, but this is a pretty definitive, oh, by the way, an indictment is on the way. So he knew that an indictment had to be coming close in time. The subpoena was issued to the attention of Travis Story. The subpoena was served on April 10th, 2020. A cover letter dated April 9th directed to Story's attention was included. In the letter, Fivestone. I keep saying Firestone. Sorry, like Firestone tires. I mean Fivestone. I'm just going to keep reading that wrong. Apologies. Fivestone was informed that in lieu of personal appearance before the grand jury, it could comply with the subpoena by returning the requested records to the designated HSI special agent, Homeland Security Investigations. Every Real Housewife fan now knows what HSI means, provided that a written waiver of grand jury appearance was executed. This is all new information. We love new information. On May 5th, 2025, Stone, through Story, provided the designated HSI agent with the production of records in response to the subpoena. In addition to the requested records, Fivestone, through the attorney Story, provided a waiver of appearance and receipt of records, dated May 5th and signed by Duggar. In the waiver, Duggar was identified as a custodian of records for Fivestone, and he represented that the records produced were all the requested records. Fivestone, through Story, also returned a certificate of authenticity of domestic business records pursuant to FRE 90211. The certificate was executed and signed by Duggar. In it, Duggar represented under penalty of perjury that he was an employee of Fivestone. He was a member of the LLC and was the custodian of records. On November 3rd, Duggar filed a motion seeking to prohibit the government from attributing Fivestone's production of records to Duggar. Yes. To resolve the issue, the government's proposing we enter into a stipulation. Weird. It's like I knew that because that's just what makes sense. Because trial lawyer, but that's just what makes sense. If you guys are like, wait, are these Are these your first impressions, Emily? Yes, I didn't have time to read all of these before this stream. That's why we're doing it together. All right. Um, to resolve the issue, the government proposed entering a stipulation at trial that the records were produced by Five Stone Group LLC, DBA Wholesale Motors, and that they are true, correct, and accurate copies of records. The government is awaiting for a final response to this proposal. Look, defense, if you're going to object to it, just enter into the proposal and stop wasting everybody's time, which is exactly what the judge is going to say. Craft the stipulation, stipulate to the authenticity of the business records, or produce the custodian of records to testify about these records. Pick a lane. And I think the lane they're going to pick is stipulation. We're not going to get into this much more because the documents were produced. They're going to come to a stipulation. This is stupid to argue over anymore. And the defense is going to have to work with them to craft it. So yeah, they're just going to have to work with them to craft it. All right, let's move on to the next one. What is next? Opinion testimony. Let's see what else. We'll go to opinion testimony next, which is the defense the defense is asking the court to limit what it perceives to be improper opinion testimony regarding the nature of the CP. We heard testimony in the detention hearing, the very long detention hearing, where the agent investigating said some of the images on the computer were some of the worst that they have ever seen. The defense is trying to limit that opinion testimony. Let's see what the government's response to that is. On November 3rd, defendant filed a motion to exclude the government from presenting any evidence relating to the opinion characterizing the CP. The defendant's motion focuses on a statement made during a detention hearing in this matter, in which the testifying agent described a certain series of the CSAM as the worst CSAM that he has ever seen. He said some of the worst. Among the worst. Okay, there it is. Yeah, some of the worst, among the worst. The defendant argues that the testimony of this nature should be excluded as irrelevant under FRE 401 and 402, unfairly prejudicial under 403, and improper expert testimony. The United States does not intend to elicit any testimony in its case in chief that this recovered is worse than any other. And I said that when I read the other motion. This is the defense being mindful. The rules of evidence and the purpose of a detention hearing are substantially different than what is proper and appropriate at a trial. A detention hearing is not in front of a jury, it's in front of a judge, and it's for the purpose of determining, does this person need to stay in custody? How bad is the thing they did, who they are, their record, all of that. So it's proper in that context. It's generally not proper in this context. And the government's like, well, yeah, it's not proper in this context unless the door gets opened that like the defense is like, well, it's not even that bad. And then it's like, I'm sorry, let us get an opinion on this. I don't think the defense will open the door. I don't think this will be relevant in trial. I don't think that this will come in. So trying to figure out which layout I like better. Now's not the time to make decisions, Emily. Let us move to the next document. Let me pull that up. Yay, that one was fast. Hopefully that's the crowd goes wild. I don't know if it is. It might have been. I'm not sure which sound that was, but we're just hitting sounds. Let's see. We're going to sequestering witnesses because it also should be very fast. So, pursuant to Federal Rules of Evidence 615, sequestering of most witnesses is mandatory when requested. Why is this so long? Defendant sets forth only a vague notion that a more expansive reading of 615 is necessary. Conclusion, the United States respectfully requests the court follow its standard and customary practice with regard to witness sequestration to the extent that the defense is requiring the government be prohibited from speaking with its own witnesses during trial. The government asks the court to deny that request based on controlling authority. What I got was that the defense, what the defense was, oh, it was the wah, wah, wah sound. Okay. It was the sad trombone sound. This is the problem when I was trying to clap. I don't know my soundboard just yet, but we've got to bring some levity while we can. This motion is about keeping witnesses out of the trial from hearing what other witnesses say. Generally, the only witnesses that stay in the courtroom are witnesses who are done with their testimony and excused, and law enforcement witnesses that are the investigating officers that have already interviewed everybody and have heard all the evidence anyway. So this isn't going to be a big deal. The court's just going to say, okay, the witnesses can't be inside the courtroom. They're trying to clarify whether the defense is trying to go one step further to try to limit something more. I don't think that's what the defense meant. I think that the court will be like, yeah, witnesses can't watch other witness testimony unless they're experts. Experts can sit in and watch the witness testimony. So the forensic expert, the computer experts can sit in the room and watch the other testimony, things like that. So that is that. And we're done with that one. Okay, let's try this. We finished that motion. Yay. All right. Let's see. What's next? Juvenile allegations are going at the end. Adultery or addiction is going at the end. Questions that the defendant declined to answer. That one's what's going next. All right. Order of shortest to longest is what we're trying to do. Where are you going, Fred? He was playing catch yesterday. This cat. I've never had a cat that likes to play catch the way this cat likes to play catch. This is defendant's statements during a non-custodial interview, but what it really is there are questions that the defendant said I'd prefer not to answer. And the defense is saying, look, if he chose not to answer a question, the government can't say, hey, here's the answer. And the government shouldn't be allowed to say, okay, he denied answering this question. Or they asked this question and he said, I'd prefer not to answer that. So they're trying to limit the government from asking about the things that the defendant's like, yeah, I would prefer not to answer that. I'd prefer not to answer this. And so that's what this motion is about. On August 20th, the defendant moved to suppress the statements he made to law enforcement in a voluntary non-custodial interview during the execution of a search warrant to search his business, arguing that those statements were obtained after he invoked his right to counsel. The court denied that motion. The United States does not intend to introduce in its case in chief any portion of the 10 portions of defendant's recorded interview identified in this motion. The United States reserves the right to introduce any portions of the defendant's non-custodial interview during cross-examination or rebuttal as those portions may be relevant. And this is the government saying, yes, we're not going to elicit that in our case in chief. It's not relevant, but it can become relevant, and we're reserving the right for it to become relevant. Any ruling on such use of the interview at this stage, however, will be premature. The defense motion should be denied as moot. The court will probably not deny it as moot. The court will probably say this isn't ripe yet and just put it over until it is. Or say, you're right, these aren't going to be used. We'll readdress it if the door is opened. And that happens a lot in pretrial practice, but the defense has to raise these issues, or some of these issues can't be raised. And that's what they're doing. And I think they've done so in a fair way. I mean, this is their job as defense attorneys. So let's see. What is next? I think we got all of the easy stuff. Let's get to juvenile. Let's do the Ashley Madison stuff next, because the government didn't seek to introduce the Ashley Madison stuff. The government's only seeking to introduce the prior statement with regard to the adult content. And we've already gone through the defense motion to not talk about the adult content, the defense response to the government's motion to talk about it. So now we're going to talk about this. So, let's go ahead and pull that up. All right. The defendant is charged in a 2-count indictment. We know that the government filed a motion. On November 3rd, the government filed a motion requesting the court issue a pretrial ruling deeming admissible prior statements made by the defendant regarding his online adult content addiction. As explained in the government's motion in Limine, evidence regarding the defendant's asserted addiction to adult content is admissible as a statement of a party opponent as intrinsic evidence that provides necessary context. with regard to Covenant Eyes. Further, the government does not intend to elicit testimony in its case in chief regarding Duggar's infidelity. Um, oh, we love the government response. The government adopts those same arguments in response to the defendant's motion and will not repeat them here. Yay! We've already addressed it. Perfect. Further, the government does not intend to elicit testimony in its case in chief regarding Duggar's infidelity or the Ashley Madison website. However, government reserves the right to question Duggar should he take the stand on his character. I can't imagine he'll take the stand. That would be a terrible plan. That would be a terrible plan. But it's the defendant's right. The defendant gets to choose, but it would be a terrible plan. But Duggar might be arrogant enough that he's like, no, I'm going to absolutely explain to this jury why they should believe me. That would be fascinating. It would be a terrible idea, but it'd be fascinating. At this point, evidence related to Duggar's adultery would be relevant and ripe for cross-examination. All right, we're done with that one. On to the next. Oh, we're almost out. We're almost out. One left with regard to juvenile allegations, and the government might say, look, we've already made the motion. The motion's over there. Let's just keep the arguments over there. So let's see what the government's response is here. Somebody is asking, should I know who this Ashley person is? Ashley Madison was a website where married people could seek out other married people for extramarital affairs. And his name was identified in an Ashley Madison leak of users, and the defense made a motion about it. I'm going to get to questions in a minute, Danny, but low. In my opinion, based on this evidence, low. Low. I think it's low. All right. Let us. All right. Juvenile allegations. The defendants filed a motion seeking to exclude any evidence, argument, testimony, document, demonstrative, anything about allegations concerning Duggar when he was a juvenile. The allegations the defendant is referring to are the subject of the government's motion in limine to admit evidence of the defendant's prior child molestation conduct pursuant to Federal Rule of Evidence 414. The defendant seeks to exclude evidence that he was investigated for, admitted to, and received counseling for, as more thoroughly outlined in the government's motion. This conduct constitutes child molestation as the term is defined because the defendant is currently charged with a child molestation crime. And even though the crime here is regarding images, it still falls under the same rule. They're arguing that it's relevant to show the defendant's propensity to commit such crimes. We covered propensity evidence and when it's relevant with regard to that other motion. And they are going on to also talk about motive and intent to commit the crimes. They talk about the Eighth Circuit ruling. We went over this in the government's motion. This is very much reiterating what they said in that motion. The defendant addresses Rule 414 in passing in his inset motion. That's true. It was very brief. However, choosing to focus instead on the admissibility under Rule 403, which was their argument that under 403 it wasn't relevant. First, as explained in the government's motion, evidence of the defendant's prior acts, prior conduct, we'll go with that, is relevant to and highly probative of the intent, motive, identity, absence of mistake in downloading and possessing the CSAM found on his computer. So they're just reiterating their motion. They say the defendant also appears to suggest that the fact that the prior conduct occurred when he was a minor somehow renders it inadmissible. That's incorrect. I agree that that's incorrect. They're trying to argue it's too long ago to be probative. They're saying it is probative. Second, courts across the country have found that evidence of a defendant's sexually abusing a child is similar enough to warrant admission under 404 and 414. Third, the fact that the proposed CSA or the proposed conduct evidence that the defendant now seeks to exclude involves conduct from the early 2000s does not mean the conduct is so remote as to render it inadmissible. This is going to be the main motion for both parties. All the other stuff is not really going to be super determinative. And the government has conceded a lot of these. Hey, we'll stipulate to this. We'll deal with that. The prior conduct is going to be the biggest motion for them. The ruling on that's the most impactful. The second is going to be that statement about the addiction to uh, adult content. That's number two. The rest of them aren't really going to matter all that much and don't have the potential weight with a jury that those motions have. Those motions have a lot of weight with the jury and will determine the way this trial goes if well partly determine the way this trial goes, which is why the defense is trying to keep them out and why the prosecution is trying to get them in. And we will see what the judge does later this week. The judge may rule on them. The judge may hold them over until closer to trial. The judge may take it under advisement after hearing oral arguments. Those are the most important motions. And it'll be interesting to see. Under 414, I think the government does have a chance of bringing those prior acts in. Will they be sanitized? I don't know. Maybe not. I mean, this is not going to be an easy trial for a jury to parse through. They're going to have to see some of these images that he's alleged to have had because the jury has to decide whether he possessed and received CSAM or CP images. And to do that, they have to see it and decide if the thing is the thing, which is going to be really hard for a jury. But the court might say, look, based on the evidence that's already coming forward, these past acts aren't more prejudicial because they're not out of context. They're in context with the other horrible shit that this jury is going to have to see. So I'll be really interested to see what the court does on this. We're going to get to some questions. I love answering your questions. And then we're going to do like 10 minutes of questions. I don't know if I can do much more. Your girl is already having, I'm like, it's so much information in my brain over the last few days. I'm already like, ba 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 ba. So let's get to questions. I have questions. You have questions. We have questions. Let's get to questions. I'm going to try to get through some of these super chats that I missed. I'm already like, I've been drinking coffee. Oh, Fred found himself a little home back there. Didn't you, Fred? Fred's like, yes, ma'am. So I will try to get to some of the super chats that I missed. I know I missed some when the computer was or when StreamYard was down a little bit. I'm going to take a look and see if we have any indication from the jury in the Rittenhouse case in a moment. And that was it. Question. Did you see Jody Montgomery's motion to seal? No, not yet, but I saw mention of it on the Twitters, but I will pull it and share it, and then we can talk about it Friday Night Live, which is going to be on Thursday this week. Christina Miller, oh my God. I can't believe I found your live. Hi. How is SoCal? So let's see. Question, do we know if the CP was the only thing on the partition when the partition was made that might more solid? I don't know. They will know in trial, but we don't know yet. So we don't know yet. Let me see. What else? Thank you. I will always take the compliments. Question, how does the right to travel relate to brandishing a gun? I don't understand the question, but if you could parse it a little more, that would help. Question, can the government get the sisters to testify? Yes. Yes, they can. What else? Oh, yes, I totally forgot, Gail Oswald. Thank you. I meant to do that. Thank you for the reminder. I have it in here too. Let me pull back up my my drive. There was a habeas subpoena. I mean, that's really all we're going to get into. There was a habeas subpoena that is pulling out the out of custody the individual that had a conversation with Duggar when he was arrested. This is the habeas subpoena, and that person's name is Robert Franklin. He is in the Washington County Detention Center and is being held. They are asking him be transferred to Fayetteville, Arkansas, beginning on November 30th at 9 a.m. That's when trial's going to start, because they are going to have him testify, and they are going to have him testify, I would imagine, to the statements made that were alluded to in other documents where Duggar said, the reason I'm in this mess or something to that nature is because I trusted too many felons. They're going to have him bring in that statement. So that is what a habeas corpus te- testacendum ad testacendum federal court. So funny. Normally these are just like removal orders, but in federal court it's fancy. So in federal court is a petition to issue a writ of habeas corpus ad testificandum instead of a removal order, but it's a removal order. This person's in custody. Can you please bring them here? They need to testify. Thank you. And that, because we've seen that in the other government documents, I imagine that that is the heart of what this individual will testify about is I trusted too many, I trusted too many felons or something like that. It's a defendant's statement. It's a statement of a party opponent, and that's why it'll come in. So that's why they're bringing them there. Will they testify or not? We don't know. The government could order people out and not bring them to testify, but they have to have them there because if you don't order them out and then you need them to testify, the court's going to be like, you have 15 minutes to bring your next witness, and they're going to be like, yeah, we need a few days. So we will see. All right, let me get to some of the super chats that I missed early on in the stream, and then we'll get to questions. So Kristen said, yes, I wanted to be with you to watch live yesterday, but had to take a break from the chat, but was interesting to hear other perspectives. Glad to be in the Law Nerd chat today, though. The Law Nerd chat is generally a much friendlier place than most chats around the internet, and it's because we have rules. There are rules, people, and we have excellent moderators who help impose the rules that are set by me. So for the people who don't like the rules, it's okay. There are other channels to watch. You don't have to chat. You can also turn off the chat. That's an option. But what you could also do is like and subscribe because I haven't said to do that yet. So like and subscribe. Do the likey, subscribey things. Unpopular, thank you for the super chat. Said agreed. Let's drop the quote guilty by association tyranny. That was referring to earlier statements. Thank you, Meganthon Medallion, Megalodon. Megatron the Megalodon. That I did that badly all the way. Thank you for the super sticker. Belly said, question, what do you think of Binger pointing the gun at the jury with his finger on the trigger, especially after the Baldwin incident? You heard what I thought of that fuckery. I think it was a poor choice. Tracy 3 said, I think the panel over there is great. We're talking about the Rekieta stream. All sides can come together, have respectful conversations, and express your own point of view. It needs to happen more often, IMHO, without arguing and fighting. I think it's one of the things that a diverse panel can excel at is having conversation. Rachel said, in the United States, it's innocent until proven guilty. Yes, a criminal case requires beyond a reasonable doubt. IMO, there's reasonable doubt. I think the jury can very easily find reasonable doubt in the Rekieta, in the Rittenhouse case. Also in the prosecution of Nick Rekieta for making all the mean jokes about the prosecutor. I find him guilty. There is no punishment, though, other than don't join the chat. You binged over the stream. It's time for an It Binged. It is time for an It Binged. After I do super chats, I'll absolutely It Binged, and then we will get to some more questions. Rona asked, what panel did Emily go on? I want to go see it. It is over on Nick Rekieta's stream. And again, that's a caveat emptor type of a situation. Madeline said, hi, Emily. So happy to catch a Coffee and Kersey live. Hope you are well. Thank you. Matt Bond said, and now she's the spiffiest legal commentator. I mean, something about that. Well, we are our own unicorn over here. Lindsay said, thank you for your ethics. I love your corner of the internet. I love my corner of the internet too. Sometimes we venture out and sometimes we're like, no. Amy Yost, I read yours out loud. Thank you for the super chat. Yay God said, I think Binger tried to bait Richards to object so he could say, see, it's provoking to point a gun at someone. Probably Richards didn't bite and it backfired on Binger. I think that's I agree with your interpretation of how that went. I don't know if the DA thought it through that far, but if they did, it absolutely didn't work. And I don't think it's worth running the risk of infuriating a jury like that. And I mean, I treat things with a jury as kind of sacred, the same way I treat my chat. Like I am respectful of you and your opinions and your time and the fact that you are here. And I don't think Binger showed a lot of respect for the jury. I think he was condescending to the jury, and that's just not ever been my style. Different people do things differently, but that's not my style here. I think juries deserve respect. Um, and pointing a weapon at them with your finger on the trigger isn't showing them respect, in my opinion. Question: is the jury aware of the Rust incident? I mean, this jury was impaneled 10 days ago, so some of them may be, because it happened before that, I believe. So timing wise, I if I believe it happened before this jury was impaneled. So some of them may be aware, some of them may not be. CB said, oh wait, I missed one. Fair mm, Faradreek is what I'm going with. I probably did that wrong, but should the judge have scolded Binger over the gun? No. It's a tactical choice in a closing argument. It's not a wise choice, but it's also not like fundamentally improper, the same way the Fifth Amendment violations were, or getting into territory that was already ruled inadmissible was. CB said, I love watching you. Actually found you months back on Mercator's channel. I want this Rittenhouse trial to end so I can go back to watching you during the day and him at night. I mean, there's definitely different vibes. So thank you. And I think everyone is ready for the Rittenhouse trial to end and see what the jury does. Um, Melody said, love your commentary on the Rittenhouse trial. You continually prove why you're everyone's favorite legal commentator. Well, Melody, thank you. K8 Linky said, question: do you think Gage Groskowitz's civil case against the city will be affected by him possibly lying under oath? Yes. I think there will be a lot of fallout from Gage Groskowitz's testimony and from Groskowitz's um, secondary statements to the media. I think there will be a lot of fallout. But yes, I do think him omitting the fact that he was pointing a gun at Kyle Rittenhouse in his civil case will have major implications in his from it, because he said that on the stand. I think it will have large implications. We'll see what happens, and we'll see what his attorney chooses to do. Shelly Clark said, get all the coffee. That's happening after this. Melinda, thank you for the super chat. EL444 said, mad mod love, but a bit different today. Sometimes when we talk about polarizing topics, it can be. Y'all keep us sane in the chat, and the mods do that. Allison Hoffman said, I do appreciate that you do a Friday night stream. Thank you. This week it's going to be on Thursday. I've been meaning, mods, I'm sorry. I've been meaning to send that out in our mod chat, and this weekend was rough and I've completely forgotten, but I'm bumping it forward. So that's where we're at. Ashley's Pretty Little Life said, currently enjoying gorgeous Tennessee and totally understand why someone would move here. It's beautiful. It is beautiful. I love my little corner of Middle Tennessee. Ario Scorpion said, please send best wishes to Whatcom County, Washington, communities dealing with flooding after record rainfall and snowmelt, overwhelming waterways. Absolutely sending best wishes. Water damage can be so devastating. Amber said, in late and watching you double time to catch up, but thank you, Emily, for being here today when you could have rightfully taken time off for yourself. Thank you. And Catherine Marie said, yes, but he's just that arrogant with regard to Josh Duggar. Josh Duggar might absolutely take the stand based on his own hubris. OMG, it's Dana. Hi. Binger did not check it and clear the gun. Richards did, or had the officer do it. Binger had no idea if the gun was loaded. It could have been so much worse. I think Binger, and this is just, I don't like what he did, but I think Binger took for granted the fact that this weapon's been in police custody. This weapon has been separated from ammo. This weapon's been on the stand. But I think what Binger did is show a disregard for guns, a misunderstanding of guns. And if there's any gun owners on that jury, then like the gun owners in the chat, they will be more offended by his lack of gun protocol, that it actually puts Binger in the position where if there are members of the jury that are gun owners, which is completely likely given the location of the trial, that you're going to have a jury going, this is a witch hunt by someone who doesn't respect or know how to use guns. And I think it can play very badly for the prosecution, because it plays into what the defense has been arguing. The defense has been arguing that this was a rush to judgment, that they just wanted to prosecute someone, that he legally possessed that weapon. And so the prosecution should have done a more thorough investigation, and Binger's behavior played into that right in front of the jury. Question: do you think there's any truth to Lou Taylor allegedly stealing hundreds of millions of dollars from Britney's estate? I have no idea where that's coming from. Would I be surprised to find out that there are questionable monies being spent? No, I would not be surprised. But were those things that were in court documents that the court signed off on? Possibly, because I don't trust that Britney's former lawyer, Sam Ingham, was objecting to everything. So, hundreds of millions seems like a lot, but we'll see. Um, I thought she did them right, like, as the bings happened. I didn't hear this bing during stream, and normally I do, but we'll do it now because it did bing. We were I think our last stream, we were at 170,000. We're at 172. There's still time to get to 200K by, the end of the year. So we're only in November. And if you're here and you haven't subscribed yet, do that if you like. If you like the content, go ahead and subscribe. It supports me, it supports the channel, and we make it bing. Oh, it binged! Move your head! Ah! And for those of you that are new and are like, Emily doesn't have purple hair in that, it binged. Correct. That it binged came from the 100K bing when Brian and I were sitting here talking about watching the counter flip over to 100K. So that is where that bing came from. It came from the 100K bing. So the hair was not purple yet. I dyed it purple for 100K. And now I'm living my best life and I'm never changing it. Even though my mom doesn't watch on Tuesdays, even though my mom asked me if I would go back to looking normal anytime soon. So, yeah. So, yeah. This is a great question, Larissa. Are jurors allowed to take notes during trial? Yes. And we actually saw somebody who was in the courtroom giving commentary on different parts of testimony, talking about where the jurors had stopped taking notes. And it's always very interesting watching jurors when they kind of sit back like this and aren't taking notes. Body language is very important in a jury, and it's hard to give commentary without seeing that. But I don't think that the jurors should be on TV or streamed or shown. I agree with that. But when you're in the courtroom, you get a different sense for how the jury is feeling. I am taking my experience with juries and trying to extrapolate what could be going on for this jury. It's hard to know without seeing them. But yes, jurors are allowed to take pen and paper notes. Their notes generally stay in the courtroom or stay in the jury room, and they're allowed to refer back to their notes in their memory. They're also allowed to ask for evidence. So if the jury wants to see a video, they're allowed to ask for it. In Wisconsin, if a jury wants to see a video, they're going to come into open court. They're going to ask the bailiff to play a certain part, and then they're going to go back in the jury room to continue deliberating, which is why the attorneys have to be on call in the courtroom or in the courthouse so that if the jury has a question, they can come up. Sometimes when juries have questions, you can really tell which way they're leaning based on the question they're asking. And generally, when a jury asks a question, it gets sent out from the bailiff. The attorneys and the court get together, they review the question, and they craft an answer as a group. Unless it's like, can we break for lunch now? And then the judge is like, yes or no. But there's a lot going on with juries, and it'll be very interesting to it'll be very interesting to see how that plays out. Just saying said, do you really believe Nick's streams are diverse? Seems everyone is one-sided and one side only. I think a lot of us have diverse viewpoints on a lot of things. A lot of us agree on how the evidence played out in this case, but we are all coming from different backgrounds, different experience, different countries, and different areas of law that we practice. So I think there is diversity in that and in the experience of the lawyers. I definitely don't agree with a lot of the things that the panel agrees on, but a lot of us do agree on how this evidence played out, which says a lot. But if you watch like Viva and Nate, the lawyer, fighting on Twitter, they disagree about quite a lot of things. This trial, a lot of us agreed on how the evidence has played out. But we don't all see things the same way. So, let's see. Yes, jurors are encouraged to take notes. Question: if I was on the jury and the gun was pointed at me, I'd be scared and ducked. Would I have been excused? No, not for that. Because you wouldn't have done anything wrong. That's a reaction. Florida gray-haired lady, I did talk about the judge earlier. I think the judge has been patient. I think the judge has listened to the attorneys, and I think the judge has been fair. So that's that's where I think the judges come from. I think he could have been more heavy-handed on the prosecution. I think there are times the judge could have declared a mistrial, but the case just would have been retried. And the judge did the things you want a judge to do. The judge listened to the arguments of both of the attorneys and actually took them in and processed them, and when new information came up, changed their mind. So, I think the judge has done a good job at being a judge. It's not easy to be a judge. It's not easy to be a judge in a polarized trial, and I think this judge has tried to block out the fact that everything he does is being streamed and has just been himself. Um, so I don't mind seeing a judge that's willing to listen, is willing to take information under advisement, and is willing to make rulings. And I think this judge has made rulings that benefit the defense and rulings that benefit the prosecution. I have not seen a heavy-handedness one way or the other from this judge. And if I had, I would absolutely share that. Because really, I'm just watching this trial as an observer. I'm curious to see what a jury does. I was curious to see how the evidence would come out. But it's not my trial. It's not going to affect the laws in the state where I live. I'm curious to see how it all shakes down. Truly. Um, Question. Does Josh have time to still plead out, take the deal? Sarah, yes and no. The time to take the government's deal has closed. Could he still go to the judge and say, I'd like to plead to the court? Yes. He can do that up until a jury's walking in the room. He can do that after, and I've had people do this. He can do that after the first three witnesses have testified and go to the judge and say, I want to change my plea. And the judge, you essentially then plea open to the court. And then the court, you plead to both counts. And then the court determines a sentence at a sentencing hearing. So, yes, it can still happen. No, it probably won't. So, I'm in Washington right now and things are crazy, but my university still isn't closed. Which university? I started law school at Seattle U. I really love the Pacific Northwest, but it's probably because like I'm part vampire-y. Like I don't need a ton of sun. I'm okay with overcast. I loved the green and the trees, and yeah, I loved the Pacific Northwest. I loved living there. So, um let's see. Um, Thank you for taking the time so we can get the best explanations. I try to help, and I try to bring my experience and perspective, and I try to also bring at least my understanding of what the two different sides of an issue are, so you all can decide. You people. So you people, I hate that so much. I don't know. Maybe it's the same as y'all. So y'all can decide how you think about things, how you feel about things, and how you determine things. Sophie Smith, I was unaware, based on earlier things. I've not been on social a ton this weekend. I'm very, very sorry to hear that there was a attack in Liverpool, and absolutely will keep you in our thoughts and keep Liverpool in our thoughts. A tired millennial says, question, can't the prosecution and defense agree that the CP images are what they are and save the jury from seeing it? I don't think they're going to do that. Could they stipulate? Yes. It's just like they stipulated in the Rittenhouse trial that, the cause of death of the deceased were Kyle Rittenhouse shooting them. That wasn't at issue. That's not being argued. It's whether they're self-defense or not. Could they do that? Yes. Will they do that? I don't know. So we'll see. Um, Shaylin Krause stated as a fact that there aren't left-handed guns, which is a lie. It was a gun. It was a gun. It was a gun. It was a lie. Guns do have a handedness, and it was interesting to see him do that. It's because I think he was flustered, but he did misrepresent things to the jury. He was interrupted in rebuttal twice by the judge for misrepresenting things to the jury and saying things to the jury he shouldn't, and that does not play well for a jury. I think this jury is going to be highly skeptical of the government based on their own behavior. And so if the jury has judgment calls to make. I imagine they will give the benefit of the doubt, not to the government as much as they would have, because the government is proved untrustworthy. All it takes is one juror that has any knowledge of guns and was paying attention to the defense closing where they said it's ridiculous that this gun would shoot hands because of how the cartridge ejects, to point that out and say, look, the prosecutor stood up here and told us something was a fact that wasn't a fact. And that is not going to go well. Um, Question: does Rittenhouse lose the self-defense claim for other people if he provoked them by shooting Rosenbaum? That's a really good question. I don't know if the jury will find the shooting of Rosenbaum to be provocation, but they can if they don't think it was self-defense as to Rosenbaum. So we will know what they decide, and it really is a great question. We will know what they decide, how they come to their decision on different charges. So if they find that the Rosenbaum was self-defense, then no, I don't think they're going to find it's provocation. But if they find that that Kyle Rittenhouse was not entitled to use self-defense in that claim, then they can say, look, this caused this other chain of events. And if this isn't justified, then this chain of events is not justified. They absolutely can come to that determination, for sure. Question: if I was on the jury and the gun pointed at me, would I have been excused? No, I answered that, which means I'm behind in the chat, and no, jurors are allowed to react to things. So, question: I saw that the jury asked for some documents regarding self-defense. What do you think that means? I think that means that the attorneys weren't clear enough in their closings, which was a concern of mine, as to how that instruction works and what the standard is. The attorneys all stated the standard differently when it came to self-defense, and it's a very confusing standard, and I think that the jury's going to need the jury instructions on that. They should already have them. And so if they're asking about self-defense, they're trying to figure out, I'm sure, I mean, speculation. They're probably trying to figure out what the standard is that we have to apply here. What does this mean? When is it self-defense? Because the defense is saying this, and the prosecution saying this, and the prosecution saying they're not right. And the law is the law. The jury has to figure out how to apply it. And the defense could have done a better job of walking the jury through how to find self-defense and what the standard is and what the jury instructions say the standard is. And I don't think they did a great job of that, but the jury might have understood the defense well. And then when the prosecution gave their rebuttal and the prosecution muddied the water, they made it harder. So I think it means they're being thoughtful, Susan. And I think they have to be thoughtful because this is a, at the end of the day, this is a murder case, where lives are changed, and the jury should take that with some weight and some seriousness. And I know, and they should. So I think that that's what they have to do. Question: will you be able to review the safety net Rosengard set up for Britney? I don't think that will ever be filed in court. I don't know what was said in court. If I see more information about what was said in court, yes, but I don't think that will be filed. How high can the Bing go? Well, let's get to 100 million and we'll see what happens. I'm so behind on the chat, you guys. I'm going to try to keep up. I'm sorry. What are the rights of the children in the JD case and their privacy in court? Catherine, I think you're referring to the children in the images. The children in the images are generally not identified by a name. I don't know if all the images are, this is a dark answer. I'm sorry. I don't know if all of the images are of actual children or computer generated. Both are illegal. Both happen. Sometimes CSAM are deep faked. Sometimes some of the images that they have identified by name are quite old. So with regard to the children in the images, they are not identified by name. The images are identified by image. So hopefully that answers the question. With regard to any children testifying, they can be protected in different ways. So let's see. I am way behind on the chat. Apologies, chat. I'm going to try to keep up. So let's see. Well, I'm glad you caught a Tuesday live. We've been streaming forever. Ivan said, I loved your Free Britney stream. We definitely had fun. When is your next Jen Shaw video? I appreciate the shade of this case. A big thank you to the mods from the UK crew. A huge thank you to the mods. I will cover Jen Shaw. Aren't really more court documents. I talked about Jen Shaw and my thoughts about Jen Shaw with hashtag no filter with Zach Peter. Then that podcast will be live on Wednesday. So I'll share that. And I talked about it on Up and Adam a little bit. But I think the place I've talked about it most recently is on Zach's podcast that will be live tomorrow. Excuse me. And then the Emily show will be live. The Emily show will be live tomorrow as well on audio. And that covers a whole bunch of topics. So, yep. Somebody asked about the current custody of Duggar's children. I believe they are with Anna, but they might be with other family members because I've seen reports that she's staying with him, but he can't be around kids. But she might have already had a baby. She was pregnant. So then she would be with her kids. So custody is just who they are with right now, but he has not lost custody of his kids. If he's convicted, I don't even know if that would happen if they're not divorced. He would have to stay away from them in the time that he goes to prison, but then would still be allowed around his kids after he gets out. So, question, Mr. Unicorn, have I tried my new stuff? I have. Thank you for the question. We are on it now. And part of it is my stream deck that is allowing me to hit my hotkeys faster, even though my cat was like knocking things off. And some of it is my audio setup with my Rodecaster Pro that I got all set up, and that has all the different sounds on it, which are fun. So that's where we can do things like, you know. So that is the kind of stuff that we got set up. So yes, I've tried it. I hope that you the audio sounds good because the mic is running through another processor now, but it's been good. I need to update a photo of the desk setup because I was doing that before everything went down this weekend, and then didn't update it. So, Mandy S says, if his wife has a newborn, she posted today about the birth, will she be allowed to bring the baby with her? Or does that make it more likely she won't attend? I think it makes it more likely she won't attend a trial, but people can be in court with babies. I don't know if I'd want to be. Courthouses are germy places. I wouldn't want my kids in a courthouse. I didn't, I wouldn't, especially when they're little. So I don't know, but you can bring them. You just have to step out if you need to feed them or change them or take care of them. So I don't know what will happen. Question, what would happen if a prosecutor doesn't truly believe the defendant is guilty? They shouldn't bring the case, K8 Linky, because they have an ethical duty to not bring a case that they don't believe they can prove beyond a reasonable doubt and should do things ethically. But when I say lawyers should do things ethically, I also realize that I've been covering the Girardi case for like a year and was horrified that was going on. So absolutely. I'm going to do just a few more questions, mods, and that me, 15 minutes a question, me, 30 minutes later. Question, can you be sent to jury duty? Yes, I can be. Whether someone would keep me on jury duty at this point is questionable, but yes, I can be. When I was a DA, I could go to civil cases, and the times I got called for a federal grand jury and then was promptly dismissed. So I've been called for jury duty. I always get dismissed because they're like, no, you know way too much. Could you imagine me in a jury room being like, you guys, what did you think of the prosecutor's closing? Like, did he seem like a dick? What do you do for a living? I'm a commentator. I'm a legal commentator. I'm a former prosecutor. I yeet immediately, but yes, I could get brought to a jury. Question, do you believe the prosecutor's back and forth with the judge and his actions is a play to get a mistrial so they can get another trial? It's it's something I can't imagine a prosecutor choosing to do, which I realize is probably altruistic of me because that would be disgusting. Um, I hope that it's not the case that the prosecutors were like, "Okay, let's mistrial this. It's not going in our favor." The goal of a prosecutor should be to do justice and get to the truth and let a jury get a case and decide what happened. And it this case felt very personal just watching it, and I hope that a prosecutor wouldn't do that. Do I think that's outside the scope of reality? No. But it should never be the way it is. It just shouldn't be. And the Fifth Amendment violation, I think, it was an intentional statement, and they tried to backtrack it going like, "No, no, we're talking about prior statements." I hope it wasn't a play for a mistrial. It doesn't mean that it's not. So, it's hard for me to wrap my head around it, you know? Um, has judge ruled on the mistrial? Can he do it after a verdict even if it's guilty on some charges? I have not seen the judge rule on a mistrial. I do not know if the defense ever filed their motion. The defense has to bring it up again for the judge to rule on it. Can they do it after the verdict? I really hope they wouldn't, because that's undermining a jury verdict, and that would seem like it was determinant. If a jury comes back guilty, then the defense can appeal those and can bring that motion at appeal. Um, if they acquit, there's nothing that can be done. So if they acquit, it's over because double jeopardy. So hopefully that makes sense, but the judge could do it before the jury comes back, but I think this judge has made it clear that he wants to let it go to verdict. So, do I think Binger should be disbarred? I think there should absolutely be some consequence. The judge can choose to set an order to show cause about those violations and hear it after the trial is done and may do that because the judge said that he did not believe it was a good faith argument and he did not believe it was a good faith mistake. Will that rise to the level of being disbarred? I don't think so. Can that rise to the level of being fined and being admonished or being disciplined? Possibly. But I also don't know what the standards are in his jurisdiction for that and what his office will choose to do. If you were waiting on this jury to come back, how long would you hope they would deliberate for? What would be a good time frame for a clear verdict, a clear guilty verdict? Less time or more time? Kendra Kraft, that's a really good question. Um Generally, a fast verdict in my it's hard because I haven't seen this jury's face. Um, I think that I think that this jury is going to be thoughtful. I think that a fast verdict is kind of out of the question because there's so much for them to go through. I think um the faster they come back, the better it is that they're not hung, but I don't know which way that goes in this case because it's a fast verdict doesn't indicate, whether they're coming back guilty or not guilty. It indicates that they've answered the questions with regard to self-defense, and self-defense is complicated to parse on the jury forms. The longer they're out, the more likely it is that somebody isn't agreeing with the rest of them, but I think a day is a reasonable amount of time to go through all the forms they have to go through. If they came back this afternoon, I wouldn't be surprised, but that would be more likely that they went solidly one way or solidly another way. Solidly, everything's not guilty by self-defense or everything's guilty and they found no self-defense. I think if they come for we're finding guilty on one or two, then that might take a little bit longer because they're going to have to parse through each thing. So we'll see. Um, let's see. Mr. Unicorn, we will come for PewDiePie's wig all the time. Because it's funny. Because look, I'm definitely not that kind of a channel. I think we're probably not. It's okay if we're not ever going to be at 100 million. I love this channel. I love the law nerds and I love our community. 200K would be very cool. And it's a goal, but am I like, let's shoot for 100 million? I don't know. I think the chats would get very, very busy. Thank you for being you and never stop purple hair. I know. Now a soundboard, you're the best. Thank you. Huge thanks to the mods. Um, let's see. How was the judge fair if he allowed the victims to be called rioters and looters, but not victim? Isn't that considered bias? I appreciate covers and commentary. I really do appreciate the question. Here's the thing. With the law, the way it is, it allows the judge to make that ruling because the rights at trial are the constitutional rights of the defendant, not of the victims. So, to protect the defendant's constitutional right, the judge is allowed to make calls like that to say, hey, because it's a self defense case, the word victim is too loaded because it implicates guilt. So I can understand why the judge did it. I don't think it was a biased ruling. Also, I think there was a lot of evidence that shows that some of the people were involved in burning things and in rioting. I don't think they referred to the crowd as looters, but I don't think they referred to the specific victims as that. So I don't think it shows bias. I think it's the system working the way that the system works when the defendant has the rights that are protected, which can be very frustrating in a lot of cases. So Judith is saying that that Anna Duggar had her baby and named them Madison. Is that Madison the same spelling as Ashley Madison? I'm sorry, I can't. I can't help myself. I just no, I know it's a different spelling. We've been talking about Ashley Madison quite a lot based on these legal motions. So, yep. I'm gonna get to like 2 more, and then I've got to scoot. It's been like 3 hours. Will Krausenbinger be investigated for the allegation of pressuring a witness to change his statement? I'm sure their office is going to have a lot of questions about that. I have a lot of questions about that. And there should have been an investigator there as well. It would have been the prosecutors and a police officer. I don't think they handled that witness well at all. Yeah, I don't think they handled that witness well at all. So yes, I think that their office will definitely have some questions about that. What will come of it? I don't know. So, we will see. Um, I'm gonna make sure I get to everything, and then we are going to scoot. Dusty said, "I am a stay-at-home mom and look forward to all the lives and your podcast. I feel connected and not isolated." Well, Dusty, thank you. We are here to have all of the conversations for sure. Um, that is what we're doing. Um, Kayak Dog said, curious on Emily's opinion. I'm going to take this as a question, and this will be the last one. Curious on Emily's opinion about the prosecution in the Rittenhouse case deciding to put a potential critical eyewitness on ice by charging them with arson and continually delaying the case. I thought it was slimy, but also the power of the state can do that. I also think that with regards to that, it shows a lot about how the prosecution felt about the strength of their case. If the prosecution's trying to get to the bottom of things, why not bring all the witnesses instead of making sure that the witnesses have a First Amendment right and can't come testify? Like, what are they going to say? And what are you afraid of? And shouldn't you want to put all the evidence out there and let the jury decide? Or are those eyewitnesses not being brought because those eyewitnesses go against the prosecution's theory of the case, which the defense can't bring them. The prosecutor can be allowed to the prosecution can be allowed to do stuff like that is concerning. So, yeah, it makes you question how strong they thought their case was when that was the choice. So, that's what it is. Um All right, let us wrap, law nerds. I appreciate you for being here. Don't forget to like and subscribe on your way out. Um, Tomorrow, there will be a new episode of The Emily Show on your favorite podcast app. We will be here for Thursday Night Live. We're going to call it Friday Night Live, but on a Thursday. Kind of like Taco Tuesday, but on a Friday. Friday Night Live, but on a Thursday. Mods, I will be in touch in the mod chat about that. And then we'll go for the verdict. When the verdict comes down, I will share on social media. I will probably not stream live. I will give a breakdown of my thoughts, and then we'll address it on the next live stream that comes up. And then that's it. So thank you for the mods. I know that polarizing topics can mean polarized chat, and it is a lot of work, and I appreciate you. Law nerds, I know you appreciate them too, because it's what keeps our chat and our community really special. So thank you, everyone. Take care of each other. Take care of yourselves. And I will talk to you in the next one.
Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.